Hello everybody. Hello, welcome, hello, happy Saturday. I'm coming out a little early to hopefully get everything set up here. So, hello. So, yes, I will be going through an order that just came down just a few days ago. So, let me make sure I'm in frame here though. So, how is this? Is this in frame, everybody? Hello, welcome. Hi, Mandy. Good to see you. Jordy, good to see you. Everybody. Hello, Jack. Yes, it's in frame. Okay, excellent. Thank you. Thank you so much. Thank you. Yes, so I came across this order. This was kind of an older case, and I'll wait here just a little bit different, but a little bit until I get started. But yes, this is a order dismissing a motion to disqualify off of a lawsuit brought by Trump last year against Hillary Clinton. And his attorney and him were actually given over $1 million in sanctions for bringing a frivolous lawsuit. How interesting is that, right? So I thought I would take you through the frivolous lawsuit sanction order, and then on the appeal, because of course he appealed, there was a request to disqualify the judge, and the judge said no. Yes. Yeah, it's quite a bit. So it's a really interesting situation. Yes. Yes, this was a lawsuit he filed against Hillary Clinton and multiple defendants, claiming that they defamed him during the 2016 election. So it's not new. This was dismissed and sanctions were granted January of this year. So, I mean, it's kind of new, but then he appealed it. And during the appeal, he had filed to disqualify the judge, which we're all familiar with now. And so the judge just sent down this order just a few days ago on his motion to disqualify. So the last motion was just done. So not very long ago, just a few days ago. But this is a really interesting case because of the amount of sanctions that were handed out for bringing a frivolous lawsuit. So I thought it would be interesting to go through this tonight. So yes, the judge starts out with, this case should never have been brought. Yes, exactly. I think the judge in this case is amazing. This was filed in Florida, and the judge is Middlebrooks, and he's just a fascinating character. He really put a lot of time into putting this order together. I'm incredibly impressed with that. Hello, everybody. Hello. Good to see you. But this case is fascinating. So I wanted to take everybody through it. As soon as I started reading it, I was like, oh my gosh, I got to do this on the live tonight. So it's a great piece of writing. It's a great story the judge has to tell us here. It's a good story. Why can't the public sue for pain and suffering? Well, it has to be attached to a particular person. So just like a general intent to do harm is hard to sue for, you have to show a particular person was intended to be harmed. So that's really where our big problem is. I'm just getting started, Cece. Just getting started. Haven't even started going through the document yet, but this is a lawsuit between Trump and Clinton. It was ordered, sanctions were done, and in January it was appealed. And oh, you bet, Cece. And so just on the 15th, so just a couple weeks ago, just a few days ago, the judge ordered a dismissal of his motion to disqualify the judge on this case. So this just came out, so I thought it would be a great opportunity to really go through. Yes, I think it's fire too, but to really go through this judge and how he decided to kind of set things straight. I thought it was really good. So, good evening. Yes. Oh, yes. Happy to hang out and chat about this. Yes, exactly. Yes, we've got this is pretty significant sanction. I think it came out to a little bit over $1 million for filing a frivolous lawsuit. So, Trump and his lawyer filed this lawsuit against Hillary for statements made during the 2016 election. And so he sued her, and the judge said, you know what, this is ridiculous, and we're not going to do that. So we've got sanctions. And then on the appeal, Trump had asked him to be disqualified, the judge to be disqualified, and the order came down just here on the 15th, so not too long ago, saying, no, I'm not going to be disqualified. I'm not. I'm going to go ahead and take care of this situation. So, yes. Oh, yes. Thank you. Thank you. Yes. Hello. Welcome. Welcome, everybody. Good to see you. Happy to be able to have some time tonight to say hello to everyone. And it's such an interesting case, too. So, I'm very happy to share with everyone. I mean, it's good. It's just good stuff. Whenever you find a nice order, well-written order, you always want to take a minute and be like, oh, this is good stuff. Oh, thank you, Catherine. Thank you. Yes, I have kind of a mixed bag tonight. So a bit of a mix. Always kind of fun to shake things up once in a while. So I've got that going on. But I will be going through the order for sanctions first, going through that, because it's just so good. It's so well written, and it really explains, I think it does a really good job of explaining how they work out sanctions. So any cases that you see coming up that have sanctions, this is really long. This is a really long, good way of explaining how it goes. How long until the laughing starts? Well, I kind of already laughed a little bit in preparation. So hopefully, just recently tried to sue Hillary for stuff in 2016. He filed this in 2022. So the statute of limitations hadn't run, but it had gone through a whole process. And then the judge had issued this order for sanctions in January of this year. So January, and then after this order came out, Trump had appealed and had filed a motion to disqualify the judge. The judge issued an order dismissing that motion to disqualify, and that order was just issued on the 15th of this month. So it's been a long process, but I think it's a great order talking about frivolous lawsuits. So who was the lawyer? This was Trump's lawyer in this case. I want to make sure I get his name right. Let me see. Let me double check here. I had a hard time trying to figure out his name. Just a minute here. Well, we'll get through it. I can't remember his name off the top of my head, but we'll be able to get his name in here in just a few minutes, because he does talk about him in the case. Vanderveen? Yeah. Is that it? Is that how you say it? Yes, I will put it up, Squee. I should be pretty much up to date on my YouTube, so I should have almost everything up on that. So, what? Cole got muted? Oh no, Perry Mason? Perry Mason got muted? Oh no, already? Are we already? Are we already muted? No, oh no. Oh yes, I'm happy to be here. Okay, hold on. Yeah, I'm just getting started, so we're doing a good job here. Do I need to unmute somebody here? Hold on, everybody. Hold on. Sorry. Oh my goodness. Oh my goodness. Where are we here? Go into here. Just a minute. Did Perry get... Okay, you unmuted. Thank you. Thanks for unmuting, Alan. Appreciate it. Oh my goodness. That's a rough start. That's a rough start if Perry Mason's already getting muted. Why do they have numbers on the side? I'm not sure what you mean, numbers on the side. You mean up here? That's our electronic filing system, Mason. Yes, this is just how all of our electronic filings are all filed up here. No, I believe they have until Monday for Trump to respond to the DC request that Jack made regarding the public information. And then by Saturday, I think, or Sunday, Jack can reply to that. So, that's what's going on there with that. So we've still got some time. Help identify the documents within the case. Lots of oh yeah. And as you can see, this order for sanctions is document 302, and the order that came down that I'll go through is document 342. So I mean, there's just so much. There's so many. So yep, it could be. All right, so let me go ahead and get started. I've got a few moderators in here already. So I would just remind everyone to please just be respectful that we are, using another, we're on somebody else's machine here. So we're in somebody else's room, somebody else's house. This is TikTok's house. So let's be respectful in the comments, please. Thank you. All right. Yes, here we go. So as I had started off by saying, I'll just go ahead and dive right in of my explanations. Yeah, it's a lot. So this case was filed originally early in 2022, and it had to do, we'll go through it, but it had to do with some issues that were brought up during the 2016 election. So he had sued Clinton and et al. In order to hold them accountable for things that were said during the campaigning. So his suit was not successful. I'll just put it that way. But what came up then was all this information came forward for this trial. And eventually this judge was like, this is ridiculous, and set out an order on sanctions. So sanctioning Trump and his attorney for filing a frivolous lawsuit. So this order takes us through kind of his history of doing this and the judge's rationale, as well as how much he felt was appropriate for sanctions. So after this, we had an appeal and a motion for the judge to disqualify himself, which he came back and issued an order on the 15th of this month. So I'll go through that next. But let's get started then here on this order for sanctions. Now, this was filed 1/19, so January of this year. Here we go. Order for sanctions. This case should never have been brought. Its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it. Intended for a political purpose, none of the counts of the amended complaint stated a cognizable legal claim. 31 individuals and entities were needlessly harmed in order to dishonestly advance a political narrative. A continuing pattern of misuse of the courts by Mr. Trump and his lawyers undermines the rule of law, portrays judges as partisans, and diverts resources from those who have suffered actual legal harm. That's pretty harsh for the first two paragraphs. I previously granted defendant Charles Nolan's motion for sanctions brought pursuant to Federal Rule of Civil Procedure 11. Now before me is a motion seeking sanctions brought by 18 other defendants. Upon consideration of the motion, response, and reply, for the reasons that follow and also for those stated in my previous order, sanctions are awarded. So let's get into the background. Number one, background. Plaintiff initiated a lawsuit in March 24th of 2022, alleging that the defendants, blinded by political ambition, orchestrated a malicious conspiracy to disseminate patently false and injurious information about Donald J. Trump and his campaign, all in hope of destroying his life, his political career, and rigging the 2016 presidential ally in favor of Hillary Clinton. The next day, Alina Habba, this is the attorney, Mr. Trump's lead counsel told Fox News' Sean Hannity, "You can't make this up. You literally cannot make up a story like this. And President Trump is just not going to take it anymore. If you are going to make up lies, if you are going to try to take him down, he's going to fight you back. And that is what this is. This is the beginning of all that." And then here we have an end note, and we'll bump down, reciting Fox News. Since then, she then explained on Newsmax, "What the real goal of the suit is democracy, is continuing to make sure that our elections, continuing to make sure our justice system is not obstructed by political enemies." That cannot happen, and that's exactly what happened. They obstructed justice. They continued the false narrative, the grand scheme, and you could not make up to take down an opponent. Oops. This is un-American. And note again, we've got a Newsmax quote here. On April 20th of 2022, less than a month after the complaint was filed, Hillary Clinton moved for dismissal with prejudice. Her motion identified substantial and fundamental factual and legal flaws. Each of the other defendants followed suit, pointing to specific problems with the claims against them. The problems in the complaint were obvious from the start. They were identified by the defendants not once but twice, and Mr. Trump persisted anyway. Despite this briefing and promise to cure any deficiencies, plaintiff's counsel filed the amended complaint on June 21st of 2022. The amended complaint failed to cure any of the defects. Order of dismissal, September 8th. Instead, plaintiff added 80 new pages of the largely irrelevant allegations that did nothing to salvage the legal sufficiency of his claim. The amended complaint is 193 pages in length. Ouch, that's a lot. With 819 numbered paragraphs, and contains 14 counts, names 31 defendants, 10 John Does described as fictitious and unknown persons, and 10 ABC corporations identified as fictitious and unknown entities. On July 14th of 2022, the United States moved pursuant to the Westfall Act to substitute itself as defendant for James Comey, Andrew McCabe, Peter Strzok, Lisa Page, and Kevin Kleinsmith. On January 21st of 2022, I granted the motion to substitute. On September 8th of 2022, I dismissed the case with prejudice as to all defendants except for the United States. Here's our end note here. Bumping down, the United States motion to dismiss under Federal Rule 12bi was granted. An amended complaint as to it was dismissed without prejudice. Back up again. I issued a detailed and lengthy order, which I incorporate by reference here. I found that fatal substantive defects, which had been clearly laid out in the first round of briefing, precluded the plaintiff from proceeding under any of the theories presented. I found that the amended complaint was a quintessential shotgun pleading, that its claims were foreclosed by existing precedent, and its factual allegations were undermined and contradicted by the public reports and filings upon which it purported to rely. I reserved jurisdiction to adjudicate issues pertaining to sanctions. That's a lot. Undeterred by my order and 2 rounds of briefing by multiple defendants, Ms. Haba continued to advance plaintiff's claims. What does with or without prejudice mean? Sure, so with prejudice means you may not file it again. Without prejudice means you need to go fix whatever's wrong with it, and then you can refile it. So if it's with prejudice, you're not allowed to bring the case again. That's the key to it. In a September 10th interview with Sean Hannity, the host asked her, and this is his attorney again that we're talking about, Ms. Haba, why isn't Hillary Clinton being held accountable for what she did? Ms. Haba's response reiterated misrepresentations on which this lawsuit was based. Because when you have a Clinton judge, as we did here, Judge Middlebrooks, which, by the way, is the judge writing this order, just FYI, okay, who I had asked to recuse himself, but insisted that he didn't need to. He was going to be impartial, and then proceeds to write a 65-page scathing order where he basically ignored every factual basis which was backed up by indictments, by investigations. This isn't looking good here. This is about the judge, the Mueller report, etc., 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 not to mention Durham and all the testimony we heard there. We get dismissed. Not only do we get dismissed, he says this is not the proper place for recourse for Donald Trump. He has no legal ramifications. What is the proper place for him? Because the FBI won't help when you can do anything. Won't help when you can do anything, obstruct justice, blatantly lie to the FBI, Sussman's out, he gets acquitted. Where do you go? That's the concern for me. Where do you get that recourse? Here's a end note here. This is a transcript from Fox. She also indicated that while Mr. Trump doubted the suit would succeed, she nevertheless fought to pursue it. You know, I have to share with you a story. Again, this is his attorney talking about this judge to Fox. Sean and I have not shared with anyone. The recourse that I have at this point is obviously to appeal this to the 11th Circuit, as Greg said. But when I brought this case and we were assigned, this judge, and we went through the recusal process, we lost 5 magistrates, including Reinhardt, who's dealing with the boxes, as we know. The former president looked at me and told me, you know what, Alina, you're not going to win. You can't win. Just get rid of it. Don't do the case. And I said, no, we have to fight. It's not right what happened. And he was right. And it's a sad day for me personally because I fought him on it and I should have listened. But I don't want to lose hope in our system. I don't. So, I'm deciding whether we're going to appeal it. This isn't looking good here. Defendants now move to recover attorney's fees and costs under Federal Rule of Procedure Rule 11, the Defendant Trade Secrets Act, and or this court's inherent power. In Part 2, I find that a sanction under this court's inherent power is appropriate. I do so by examining plaintiff's and his lawyer's conduct throughout this litigation. In Part 3, I look to plaintiff's conduct in other cases, and in Part 4, I determine the reasonableness of defendant's attorney's fees and costs. All right. Number 2, analysis of litigation conduct in this case. All right. Tampering with the administration of justice involves far more than an injury to a single litigant. It's wrong against the institution set up to protect and safeguard the public. Citing the Chambers case, a court's inherent power includes the ability to assess attorney's fees and costs against the client, the attorney, or both when either has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. The inherent power of a court can be invoked even if procedural rules exist which sanction the same conduct. If the informed discretion of the court, neither the statute nor the rules are up to the task, the court may safely rely on its inherent power to sanction bad faith in conduct in the course of litigation. So this is a huge moment, okay? If we've got bad faith in any case when it comes to attorneys, we're going to have problems. So the court is already saying, look, I've got the power and I'm going to use that power. So he's setting that out in his case law here. The key to unlocking a court's inherent power is a finding of bad faith. Again, this is the essential element that we'll be looking for. The inherent powers standard is a subjective bad faith standard. However, absent direct evidence of subjective bad faith, this standard can also be met if an attorney's conduct is tantamount to bad faith, meaning the attorney's conduct is so egregious that it could only be committed in bad faith. An attorney's conduct is tantamount to bad faith if he recklessly raises a frivolous argument. Recklessness alone does not satisfy the inherent powers standard, but recklessness plus a frivolous argument suffice. The inherent power is both broader and narrower than other means of imposing sanctions. It's broader in the sense that while other sanction mechanisms only reach certain individuals or conduct, the inherent power extends to the full range of litigation abuses. In my informed discretion, I find Rule 11 and the Trade Secrets Act are not up to the task of confronting the litigation abuse involved here. Rule 11 is backward-looking, limited to pleadings and motion abuse, and experience has shown it to be ineffective as a deterrence. Ooh. See Rule 11, the Advisory Committee notes here. Section 1927 only applies to unnecessary filings after the lawsuit has begun, and the Defend Trade Secrets Act may only provide limited relief. The purpose of the inherent power to sanction a party is to vindicate judicial authority without resorting to contempt of court and to make the non-violating party whole. Here we are confronted with a lawsuit that should never have been filed, which was completely frivolous, both factually and legally, and which was brought in bad faith for an improper purpose. Mr. Trump is prolific and sophisticated litigant who is repeatedly using the courts to seek revenge on political adversaries. He is the mastermind of strategic abuse of the judicial process, and he cannot be seen as a litigant blindly following the advice of a lawyer. He knew full well the impact of his actions. As such, I find that sanctions should be imposed upon Mr. Trump and his lead counsel, Ms. Haba. Whoa, that's a lot. That's a lot. He's mad. Yeah, he's mad. I mean, as far as his knowledge of how to use the system goes. All right, here's A. The case was initiated by a shotgun pleading designed to serve a political purpose. The deliberate use of a shotgun pleading is an abusive litigation tactic which amounts to obstruction of justice, citing case law. This case involved 3 categories of shotgun pleadings condemned by the 11th Circuit. A. Complaint containing multiple counts where each count adopts the allegations of all preceding counts, causing each successive count to carry all that came before and the last count to be a combination of the entire complaint. Ugh, that's a lot. 2, a complaint that is replete with conclusory, vague, and immaterial facts not obviously connected to any particular cause of action. And 3, a complaint that asserts multiple claims against multiple defendants without specifying which of the defendants are responsible for which acts or omissions, or which of the defendants the claim is brought against. Wow, that's a huge problem. Judges hate that. You got to be specific when you are pleading your case out. It just means one that's been kind of thrown together, like quick and dirty is what a shotgun pleading is. It's not a well-written, it's just rushed and put together. Yes, hello. Yes, we're going through the judge's motion on the Trump v. Hillary case ordering sanctions. So I'm just getting going on this. So here we go. I find that the pleadings here were abusive litigation tactics. Wow, he's not even messing around. The complaint and amended complaint were drafted to advance a political narrative, not to address legal harm caused by any defendant. The 819 paragraphs of the 186-page amended complaint, he seems pretty upset about that, are filled with immaterial, conclusory facts not connected to any particular cause of action. So let's just take a moment. Is this true of all of his cases? Isn't this like what he does? A lot of accusations that are not relevant at anyone specifically. Right. Yeah, you're just hoping to catch somebody in the crossfire. Okay. Yeah, this seems to be, this is strategic. So really any of the cases that are going on could use the same language. Consider the incendiary charge that Mr. Comey, the director of the FBI, conspired with Ms. Clinton to maliciously prosecute him. Leaving aside the fact that Mr. Trump was never prosecuted, examine the allegations in the amended complaint pertaining to Mr. Comey. The first mention of Mr. Comey, other than identifying him as a party, was in paragraph 349. Therefore, senior FBI officials Comey, McCabe, Page, Strzok, and DNC and Clinton orchestrated a plan to falsely accuse Flynn of colluding with Russia to protect the potential dissemination of the intimate details of their plot. The next few paragraphs pertain to the FBI's investigation of Mr. Flynn, Mr. Trump's former security advisor, who was subsequently fired for lying to the vice president and the FBI. The amended complaint alleges that Mr. Comey scrambled to reopen the investigation into Mr. Flynn, met with Mr. McCabe to discuss the investigation, and decided not to notify the incoming Trump administration of the investigation of Flynn. Next, the amended complaint cites a letter from the Director of National Intelligence, John Ratcliffe, to Senator Lindsey Graham. Oh, here we go. Look at that. Mr. Graham's involved again. Ratcliffe's letter stated that Clinton and her campaign conceived the false Russian collusion story to protect Clinton's presidential bid, which was at the time in trouble because of the revelations about her illegally using a private email server. Oh my gosh, can we not make it through one night without the email server involved? Goodness gracious. To handle classified information, Ratcliffe confirmed in the letter that Obama, Comey, and Strzok knew about it. Good grief. That's a lot. The amended complaint continues with allegations about a meeting between Mr. Comey, President Obama, Vice President Biden, and Sally Yates, then a national security advisor, while President Obama directed Mr. Comey to investigate Mr. Flynn and not inform Mr. Trump. The amended complaint alleges that Mr. Flynn was interviewed by the FBI and that subsequently Acting Attorney General Yates informed Mr. Trump's White House counsel, Don McGahn, and Mr. Flynn misled Vice President Pence and other administration officials about the nature of his conversations with the Russian ambassador. The amended complaint then concludes, ultimately, the defendants, including Comey. Yes, we'll go down to footnote 6. Did I miss it? Thank you for reminding me. Where did I miss it? Oh, it's up here. Yep. I'll bump down just in a minute. The amended complaint then concludes, ultimately, the defendants, including Comey, McCabe, and so on, were successful in causing Flynn to be ousted as National Security Advisor. So let's bump back up. Again, we've got this quote here. There's this letter. So let's bump down to this footnote. This provocative allegation stirred my curiosity. This is the judge speaking. So I looked up the Ratcliffe letter. The allegation in the amended complaint fails to mention that the information came from a Russian intelligence analysis and that Mr. Ratcliffe commented the IC or intelligence community does not know the accuracy of this allegation or to the extent to which the Russian intelligence analysis may reflect exaggeration or fabrication. And he's quoting this letter from John Ratcliffe to Senator Lindsey Graham, U.S. Senate. Oh, Mr. Trump's lawyers saw no professional impediment or irony in relying upon Russian intelligence as the good faith basis of their allegation. Oh, that's harsh. Struck? Is it struck? Thank you. Okay, that's a lot. Whoo, he got into trouble. All right, so he's not impressed with this letter. You got that. Yeah, that's an ouch. That's an ouch. Okay, so I'm going to call this struck then. I'm going to forgive me. I will probably say it wrong. The amended complaint then turns to the FBI's Crossfire hurricane investigation and 4 count approved FISA applications targeting Carter Page. The amended complaint alleges the FISA application were reviewed by numerous FBI agents, the FBI attorney, and the National Security Division attorneys, and as required by law was ultimately certified by the FBI Director James Comey and approved by then Deputy Attorney General Sally Yates. From there, the amended complaint states, in fact, no probable cause existed and there was no truth to any of the allegations against Carter Page, Donald Trump, or the Trump campaign. The amended complaint then discusses the FISA warrant application and Mr. Comey's approval of those warrants and alleges Mr. Comey was aware or should have been aware that there was no evidentiary basis for the FISA application and that the Steele dossier was not a credible source. What is this madness? This judge has gone looking into this situation. He's not even playing around. FISA. Okay. I'm sorry, everybody, my accent. I will mess up everybody's name. Pfizer. goodness. This is bringing Graham into all of this, so he's not going to be happy his name's mentioned. True. True. The next mention of Mr. Comey. Does anyone remember Mr. Comey? Does anyone remember him? Remember what a big mess that was? Ugh, that was awful. The next mention of Mr. Comey states that on May 8th of 2017, he was fired from his position as director of FBI. Yeah, that was crazy. The amended complaint then alleges that Mr. Comey had documented several of his interactions with Mr. Trump in a series of memos. Oh yeah, remember the Comey memos? Oh my gosh. Wow. And that after leaving the FBI, Mr. Comey shared those memos with a friend who he directed to leak to a New York Times reporter. Whoa. The amended complaint continues. 453. The outcome that Comey desired per his own admission to Congress was to prompt the appointment of a special counsel to investigate Donald J. Trump's alleged conspiracy with the Russian government. 454. The IG's report noted that Comey had set a dangerous example by releasing sensitive information to create public pressure for an official action. Okay then, and moving back up, 455, Comey was successful in getting the special master appointed due to his unlawful leaking of the information, even though Comey didn't have enough evidence to pursue it in his own official capacity. 456, in May of 2017, Robert Mueller was appointed as special counsel to oversee the previously confirmed FBI investigation of Russian government efforts to influence the 2016 presidential election and related matters. Now let's bump down, look at our footnote. In a footnote to paragraph 456, the amended complaint cites to the Justice Department announcement of the appointment of special counsel. That statement by Deputy Attorney Rosenstein, also sued by Mr. Trump, reads in part as follows. My decision is not a finding that crimes have been committed or that any prosecution is warranted. I have made no such determination. What I have determined is that based upon the unique circumstances, the public interest requires me to place this investigation under the authority of a person who exercises a degree of independence from the normal chain of command. Press release from special counsel. Back up we go. This is what the plaintiff's lawyers considered to be the short and plain statement of the claim that Mr. Comey maliciously prosecuted Mr. Trump and conspired with Ms. Clinton to do so. So that's it. Those pieces in the claim that he had filed, those pieces are the only pieces regarding this malicious prosecution. So that's not very much. That's not very much. These allegations about investigating Mr. Flynn, signing FISA warrant applications pertaining to Mr. Page, or leaking information about his interactions with Mr. Trump do not allege that Mr. Comey initiated an investigation of Mr. Trump, much less a prosecution. And the implausible claim that Mr. Comey conspired with Ms. Clinton, given the impact of his announcements on her 2016 campaign, not only lacks substance, but is categorically absurd. The amended complaint is a hodgepodge of disconnected, often immaterial events, followed by an implausible conclusion. This is a deliberate attempt to harass, to tell a story without regard to facts. In order to understand the scope of this abuse, multiply the above discussion by 31 defendants and their lawyers, forced to try to analyze and defend against the sprawling complaints. Whoa, this judge is on fire. I sifted through the thread of allegations against each defendant only to find they added up to no cognizable claim, and the pleadings were drafted in a way to disguise that fact. In 3 instances, the 11th Circuit, thank you so much. The 11th Circuit has found shotgun pleadings less problematic than the pleadings here as a basis for sanctions. So he's saying these kinds of pleadings can be allowed to have sanctions. In Jackson, the court described a case as an abuse of process, effectuated by filing a multi-count, incomprehensible complaint that flouted the federal rules of civil procedure and this circuit's well-established precedent by attempting to prosecute an incomprehensible pleading to judgment. The plaintiffs obstructed the due administration of justice in the district court. Ooh, that's harsh. The facts in Jackson are similar, although less egregious than here. The complaint in Jackson alleged 14 causes of action contained in 109 paragraphs of allegations, and each of the claims incorporated all previous allegations. The defendants filed a motion for more definite statement identifying the complaint as a shotgun pleading. The plaintiff did not oppose the motion but sought leave to file an amended complaint. The amended complaint swelled to 23 pages and 123 paragraphs, made minor changes to a number of factual allegations, added 2 new counts, and listed 1 more defendants in parentheses under the heading of each count. Wow, that's really bad. Anyone that drafts complaints knows how bad this is going to be. This is really bad. We shouldn't do this. Yeah, this isn't good at all. You're not allowed to do that. Oh, the Court of Appeals stated, Lemonade Squad. Oh, we love it. The Court of Appeals stated, here, after being put on notice by defendants of the specific defects in their complaint, the Jacksons filed an amended complaint afflicted with the same defects, stating that tolerating such behavior constitutes toleration of obstruction of justice. The court affirmed the trial judge's order dismissing the amended complaint and instructed plaintiff's counsel to show cause why he should not be ordered to pay double the costs, yikes, and expenses, including attorney's fees and costs incurred in defending the appeal pursuant to Rule 38 of the Federal Rules of Appellate Procedure. The court pointed out that the defendants had identified the deficiency and the 11th Circuit's precedent in their motion. If plaintiff's counsel was not aware of the precedent when he filed the plaintiff's initial complaint, defendant's motion told him all he needed to know. Nevertheless, he stood fast, brazenly filing a facsimile of his initial pleading. Similarly, here, defendant No Star identified the shotgun pleading deficiency and the 11th Circuit's precedent as one of its grounds for dismissal of Mr. Trump's initial complaint. The defendant's joint motion to dismiss the amended complaint did likewise. The plaintiff refused to acknowledge this clear precedent. Instead, he added 80 new pages, and new defendants, including his former deputy attorney general and a California congressman. Yikes! In order to rehash old grievances from the 2016 election. The other 2 11th Circuit opinions analyzed the use of shotgun pleadings to support a frivolous RICO claim. In both, the court found the tactic deserving of sanctions. In the Pelletier, the Court of Appeals reversed a denial of Rule 11 sanctions motion in a civil RICO case. Now, let's bump down here real quick. We've got a citation for the Pelletier and Byron cases. They're abrogated on other grounds. Holding plaintiff asserting, look at the jellyfish, oh my goodness, asserting a RICO claim predicted on a mail fraud need not show either as an element of its claim or as a prerequisite to establishing proximate causation that it relied on the defendant's alleged misrepresentations. I do not rely, this is the judge, I do not rely on Pelletier and Byron as they relate to mail fraud. So he's even clarifying how he's using the precedent. A more detailed analysis of why Mr. Trump lacks standing to bring his RICO claim is set forth in my order granting defendant's motion to dismiss. So, look at that. Oh, thank you so much, everybody. Thank you. Analyzing in detail the amended complaint in this case, the Court of Appeals concluded that the plaintiff failed to establish any of the required predicate acts. So this has to do with the fact that a RICO claim had been charged and dismissed. Again, charging everybody involved in this. So this was a previous denial. This case was denied previously. So to show any continuing relationship or pattern of acts or injury flowing from those acts. So he's going into, again, the rationale for the dismissal of the previous RICO case, concluding that each of the counts in the amended complaint were objectively frivolous when filed. The Court of Appeals found it apparent that the case was brought to harass the defendants. Our conclusion is buttressed by the manner in which plaintiff pled his case in the district court and briefed it on appeal. These are quintessential shotgun pleadings, replete with factual allegations that could not possibly be material to any of the causes of action they assert. Each count incorporates, can this be used as precedent in any of the current cases? Absolutely. Absolutely, it could be. Each count incorporates all of these factual allegations and states further that it is based on the conduct of the complaint attributable to the defendant and those acting in concert with him. Anyone schooled in the law who read these complaints, however, would know that many of the facts alleged could not possibly be material to all of the counts. And this is the Pelletier case again. The appellate court found the amended complaint was conclusory, baseless, and without any merit. In deciding that the claim was prosecuted in bad faith, the court rejected the thought that it might have been the product of incompetent lawyering and thus excusable rather than a tool of harassment because the plaintiff was skilled in the law and had been warned he was likely to run afoul of Rule 11. The court concluded, "We think that imposing sanctions in this case would serve the dual purpose of deterring the filing of frivolous claims and defenses, while not chilling attorneys' legitimate enthusiasm and creativity in advancing legal and factual theories. At a time when the federal courts, which are a scarce dispute resolution resource, indeed, are straining under the pressure of an ever-increasing caseload, we simply cannot tolerate this type of litigation, particularly with regard to civil RICO claims. Plaintiffs must stop and think before filing them." And again, we've got a citation here, the Pelletier case. The court only reserved the district court's denial of Rule 11 sanctions and remanded for determination of an appropriate amount, but also determined that the appeal was frivolous on its merits and awarded double costs and reasonable attorney's fees pursuant to Rule 38 of the Federal Rules of Appellate Procedure. So we've got this again. We've got the citation to this case. In Byron, the court affirmed a $400,000 sanction against counsel against Rule 11 Section 1927, the court's inherent powers, finding that the expansion of a simple garden variety medical malpractice case to include RICO and other baseless claims was frivolous from the outset and doomed to fail. Identifying the complaint and amended complaint in Byron as shotgun pleadings at 1106 and 1129, did you think before you filed? Exactly. The Court of Appeal emphasized the harm presented by the tactic and authority of Article III courts to control the practice through inherent powers. Article III courts are, of course, our federal courts. Shotgun pleadings, if tolerated, harm the court by impeding its ability to administer justice. The time a court spends managing litigation framed by shotgun pleadings should be devoted to other cases waiting to be heard. Although obstruction of justice is typically discussed in the context of criminal contempt, the concept informs the rules of law, both substantive and procedural, that have been derived and protect the courts and litigants, and therefore the public, from abusive litigation tactics like shotgun pleadings. If use of an abusive tactic is deliberate and actually impedes the orderly litigation of the case, to wit, obstructs justice, the perpetrator could be cited for criminal contempt. And this is citing the Byron case. So this is a lot. They're pretty serious here. In Byron, the court pointed out that the plaintiffs filed shotgun pleadings and frivolous claims to extort settlement of unmeritorious claims. Right? So this is a strategy attorneys can use to force the other side into a settlement by filing these kinds of bologna sandwiches, these bologna sandwich complaints. Knew what he was doing when he clustering all those court dates. Could be. Here, although his complaint asked for damages in excess of $24 million, treble damages under RICO, and attorney's fees and costs, I do not think Mr. Trump or his lawyers actually thought the defendants would ever agree to settle. So let's just take a moment and say he was asking for $24 million, triple damages under RICO. Oh my goodness. On a complaint that was bologna sandwiches, just conclusory, which means there was no factual basis. There were just statements of conclusions. So there's no basis founded in it. The suit was filed for equally improper purposes: to harass, punish for fundraising, and to advance a political agenda. B, the pleadings contain factual allegations that were knowingly false or made with reckless disregard for the truth. Those are pretty significant standards. Right. The plaintiff consistently misrepresented and cherry-picked portions of the public reports and filings to support a false factual narrative. Often the report or filing actually contradicted his allegations. It happened too often to be accidental. Its purpose was political, not legal. Factual allegations were made without any evidentiary support in circumstances where falsity is evident. See, eventually it catches up to you, you know? Examples include, all right, let's get into the examples. A lot. They've spent a lot of money on frivolous lawsuits. Yes, so the Mueller report. A section of the amended complaint is titled, "A String of Federal Investigations Clear Donald J. Trump and Uncover the Defendant's Illicit Conspiracy," amended complaint. After a 2-year investigation, the special counsel found no evidence that Donald Trump or his campaign ever concluded with the Russian government. The amended complaint further alleges that special counsel Mueller went on to exonerate Donald J. Trump and his campaign with his finding that there was no evidence of collusion with Russia. While perhaps accessible as a cable news talking point, that allegation is neither an accurate nor fair reading of the Mueller report. Ooh, let's see what he has to say here. I, Robert S. Mueller III, United States Department of Justice, report on the investigation into Russian interference in the 2016 presidential ele. 2, Robert S. Mueller III, report on the investigation as well. So he's citing the 2 reports from Robert Mueller, which, if you read those, are enormous. So he's saying that that is not an accurate or fair reading. So they put in here that Trump was completely exonerated, and the judge said that that is not accurate. Oh my goodness. All right, well, let's see what the judge has to say about it. First, the Mueller report stated that in evaluating whether evidence about collective action constitutes a crime, we applied the framework of conspiracy, not the concept of collusion. Second, in determining whether the conduct amounted to a violation of federal criminal law, whose filing is this? This is the judge's motion, or the judge's order for sanctions in Trump versus Hillary that was filed in March of 2022 regarding things done during the 2016 campaign. So he and his attorney were sanctioned. This order came out. He appealed, filed a motion to disqualify. The judge just ordered, forget about it. I'm not going to disqualify. And that came down 2 weeks ago. So we're reviewing the original motion. That is not what it said. I know. The question was whether admissible evidence would probably be sufficient to obtain and sustain a conviction. Third, the report found, while the investigation identified numerous links between individuals with ties to the Russian government and individuals associated with the Trump campaign, the evidence was not sufficient to support criminal charges. The investigation established that several individuals affiliated with the Trump campaign lied to the special counsel's office and to Congress about their interactions with Russian-affiliated individuals and related matters. That is directly from the Mueller report. Fourth, with respect to the obstruction of justice, the report states, well, this report does not conclude that the president committed a crime. It also does not exonerate him. That's pretty clear language. That's pretty specific. All right, so that goes to the Mueller report. So one moment, I'm going to hydrate here for a second. Whew. All right. So far, the Mueller report statements were incorrect. Next, we have the Crossfire Hurricane investigation. Again, the judge is talking about all the pieces that were pled out in this original complaint. Yes, oh my goodness. I know. I need to work on it. Oh, look at that. That was fun. All right. A core aspect of the plaintiff's claim in his contention that Miss Clinton, Mr. Comey, and others were responsible for the Crossfire Hurricane investigation, the complaint and amended complaint copiously cite to the IG report to support these allegations. But the IG report found that the FBI opened the investigation for an authorized purpose and with adequate factual predication that had nothing to do with the defendants or the Steele dossier. All right, how about the Charles Dolan allegations? As set forth in my order granting Rule 11 sanctions, the plaintiff alleged that Mr. Dolan was a former chairman of the DNC, not the Orange, of the DNC, and an individual with intimate ties to the Clinton campaign and one of its own associates. In fact, Mr. Dolan's lawyer told plaintiff's counsel he was none of those things. It made no difference. Despite an affidavit from Mr. Dolan saying he lived in Virginia and the fact that service upon him occurred there, the amended complaint claimed he lived in New York. The plaintiff's lawyer's excuse, there are a lot of Dolans, some of them live in New York. That was the plaintiff's excuse? Whoa, that's awful. That's not good. I just don't like it when you do that. The complaint and amended complaint alleged Mr. Dolan was responsible for allegations in the Steele dossier concerning salacious activity by Mr. Trump in Moscow. Salacious activity? Whoa. Not sure about that. I wasn't aware of the specifics of that particular activity. Mr. Dolan's lawyers warnings that this was untrue went unheeded. The defendant against sanctions, in defending against sanctions, the plaintiff's lawyers pointed to the Danchenko indictment. And we go down here, U.S. v. Danchenko. However, the Danchenko indictment does not support plaintiff's claim. Rather, it contradicts and undermines them. Well, that's not good. You shouldn't cite to something that'll undermine your claim. So let's go to the criminal indictments. The complaint and amended complaint rely substantially on the Sussman, Danchenko, and Kleinsmith indictments. They're cited down here. The plaintiff alleges that these speaking indictments not only implicate many of the defendants named herein, but also provide a great deal of insight into the inner workings of the defendants' conspiratorial enterprise. Based on the facts that they have already been uncovered throughout the course of Durham's investigation, it seems all but certain that additional indictments are forthcoming. The indictments themselves are not relevant. Well, there goes the indictments. They've got all these indictments they're using, and the judge just like, not relevant. So, okay, am I out of frame? Hold on. Let me double check. There we go. How's that? Am I better in frame here? How's that? Let me double check before I dive back in. Yeah, good. Okay, great. Thank you. I'm so glad you told me. All right, so far, the indictments are not relevant. An untried indictment is not evidence of the conduct alleged. Very true, everybody, very true. A criminal indictment should be no more than the starting point for a lawyer's good faith pre-filing investigation. The danger of over-reliance has been demonstrated here in light of the acquittals of Mr. Sussman and Mr. Danchenko. That is not to say an indictment has no significance. A grand jury has issued it with the assistance of a lawyer for the government. But a plaintiff's good faith pre-filing inquiry cannot simply ignore the facts in an indictment that contradict and undermine his allegations while touting those he likes. Mr. Sussman's indictment charged Mr. Sussman with falsely telling the FBI's general counsel he was not acting on behalf of a client when he conveyed allegations about email communications between the Trump Organization and a bank affiliated with the Russian government. But the plaintiff relied on the indictment to support his allegation of theft of trade secrets, violations of Computer Fraud and Abuse Act, and violations of the Stored Communications Act in counts 1, 7, 8, and 9. And that takes us to the next page. As the order of dismissal points out, there are legal deficiencies in these claims, but the Sussman indictment also warned the Trump lawyers of factual problems. It specified that communications involved purported DNS data reflecting apparent DNS lookups. What? Between Russian Bank 1 and an email domain. Mail 1, whatever. Email, whatever. DNS data is meant to be public and as part of the infrastructure for the internet, accessible to any entity. The indictment further advises that the FBI determined that the email server at issue was not owned or operated by the Trump Organization, but rather had been administered by a mass marketing email company and sent advertisements for Trump hotels and hundreds of other clients. The Sussman indictment does not support and instead contradicts the conclusory trade secret and unauthorized access allegations set forth in plaintiff's amended complaint. Oh my goodness. A record of the website people visited. Okay, I got it. So that thing you delete before your parents look at your browser history, right? And as noted above, the Dichenko indictment contains allegations that, if true, were fatal to the plaintiff's conspiracy claims. The Dichenko indictment states that, according to Mr. Dolan, individuals affiliated with the Clinton campaign did not direct and were not aware of Mr. Dolan's meetings and activities with Mr. Dichenko and other Russian nationals. Further, it alleges that, according to Mr. Dolan, he was aware of the specifics of Mr. Dichenko's project against Trump, or that Mr. Dichenko's reporting would be provided to the FBI. In responding to Mr. Dolan's sanctions motion, the lawyers claim their allegations were directly sourced from the Dichenko indictment. That is plainly untrue. So if a judge actually reads the attachments to your petition, you could have some problems. Okay, right. Next, let's get into the Twitter suspension. And let me just pause for a moment for anyone who is new and joining us here. I'm going through Trump versus Clinton. It was a lawsuit filed in March of 2022. This is the motion for sanctions that was filed by the judge. This is the order for sanctions filed by the judge in January. So I'm going through his order for sanctions against Trump for filing a frivolous lawsuit. Twitter suspension. To support his damages claim, plaintiff alleged that he was banned from different social media platforms, including Twitter, as a result of the misinformation campaign waged by Hillary Clinton. However, Twitter suspended Mr. Trump on January 8th of 2021, 2 days after the January 6th attack on the Capitol, because it determined Mr. Trump's tweets posed a risk of further incitement of violence. And we have an end note here. Down here, we've got the reason, I guess, what Twitter set out was their rationale. Isn't the judge supposed to read the attachments? Yes, they read, but the point that he's saying is that the way that they were written in the petition was false. And if you just took the petition at face value without further researching where they're quoting and putting their conclusions from, you're going to miss the whole point. So the problem wasn't necessarily all of the attachments. The problem was that they were making false statements, essentially. Yeah, it is frivolous. All right, so back up, here we go. Moreover, in a lawsuit Mr. Trump filed against Twitter, attempting to show state action. Okay, so we got another lawsuit here. He alleges that Democrat legislators pressured Twitter to censor him and that he was banned for exercising his right to free speech. That sounds familiar, doesn't it? Everybody, in case anybody wants to know that lawsuit, it's right here. The assertion that the Twitter ban was caused by misinformation by Ms. Clinton 5 years earlier is plainly false. Oh my goodness. Oh my goodness. All right, here's C. The plaintiff's legal theories were frivolous, foreclosed by existing precedent. The plaintiff recklessly advanced claims foreclosed by existing precedent that the most basic legal research would have revealed. It was not that the complaint and amended complaint were inadequate in any respect. They were inadequate in nearly every respect. Ooh, harsh burn. Even after that, even after the deficiencies had been identified and multiple motions to dismiss, the 11th Circuit has squarely held that to knowingly advance frivolous claims constitutes bad faith, meriting sanctions under a court's inherent powers. He's quoting the Peer case, reversing a district court's failure. Oh, Kitty, thank you. To award sanctions under inherent power based on the circuit court's finding that a lawyer knowingly pursued a frivolous claim and thus acted in bad faith. Back to this judge. I will not detail all the failings of the amended complaint here. He's so harsh. This judge is harsh. Yes, no, it's okay. It's okay, Julie. Yeah, no, sometimes judges will look through and glance through. I mean, if you're at this level, of course, the judge will take a look. But I think part of the big issue was he was saying the way that it was framed was the issue. So I think even if someone hadn't looked at the attachments or looked through them thoroughly, they wouldn't have gotten the full story. So yeah, you're okay. You're all right. Most are identified in the order of dismissal. I concluded that fundamental substantive defects precluded the plaintiff from proceeding under any of the theories he advanced. This judge is pretty harsh. In arguing against the imposition of sanctions, the plaintiff attempts to defend his legal positions. For instance, he contends that while novel, neither the time nor the inclination to explain myself to you. Pretty much. All right. For instance, he contends that while novel, his assertion that the RICO statute of limitations should be told because of the former president's duties is a compelling argument for an extension of existing law. But Clinton v. Jones does not leave room for that argument. And this is the Trump v. Vance case. I should do that case sometime. That's actually really good. Holding that the president is neither absolutely immune from the state criminal subpoena seeking his private papers nor entitled to a heightened standard of need. By the way, this Trump v. Vance case, which was decided by the U.S. Supreme Court in 2020, stated that the president has to abide by the law. I really should do a case. I should do a post on that. Then we have Trump v. United States, holding district court lacks equitable jurisdiction to block government investigations on a former president. That is especially true here, where Mr. Trump, in his personal capacity, found time during his presidency to file other civil actions. Ouch. Trump v. Mazar, Trump v. Deutsche Bank, Trump v. Com of Ways, Committee of Ways and Means. Oh my gosh, he's filed a lot of lawsuits. So, he's saying he didn't have time because he was the president, so the statute of limitations shouldn't be told on the RICO case. But meanwhile, he had time to file all these other lawsuits. Oh, thousands over his lifetime. Thousands. Yeah, there have been so many lawsuits. Yeah, all the best lawsuits. Yikes. The argument that the statute of limitations should be extended because of the tolling provision of the Clayton Act is likewise frivolous. Even were it to be applicable to RICO, none of the government proceedings identified by the plaintiff, the Sussman and Danchenko indictments, or the FEC proceeding bear any relation to RICO. And in addition to the statute of limitations, plaintiff's RICO claim failed at every step of the substantive RICO analysis. Again, he was filing a civil RICO claim against Hillary that had already been dismissed outside of this case. So just keep that in mind. That's why we keep talking about RICO here. The plaintiff does not even attempt to respond with respect to most of the legal failings of his claims. To reiterate a few, the malicious prosecution claim without a prosecution. That's really key. In order to have a malicious prosecution, you need to have an actual prosecution. That's really key. It looks like you can sue anybody you want. It can get tossed out, but it still takes a lot of time out for everybody. The theory of personal jurisdiction based on an allegation that defendants knew that Florida is a state in the United States, which was an important one. Oh my gosh. Oh my gosh. Oh, the trade secret claim without a trade secret or ownership. This judge. Whoa. The computer fraud and abuse claim foreclosed by Van Buren, and this is really hard. Obstruction of justice untethered to any official proceeding. So you need to have some kind of justice in order to obstruct it. Despite its 193 pages, the amended complaint did not come close to stating a legal claim that was never its intended purpose. Wow, this judge is upset. Number 3, a pattern of abuse of the courts. So now we're getting into the tea here. This again is by a judge, so this is all official order by a judge. Let me just make sure I'm in frame here. Am I in frame? Okay, just wanted to make sure. You have time to file. You have time to research your filings. True story, see, Marie. True story. Oh my goodness, it's a lot. Okay, thanks, Jen. I have explained why the totality of the problems with the complaint, amended complaint, and the arguments and statements of the plaintiff's counsel show that this lawsuit was filed and prosecuted in bad faith. But this case is part of Mr. Trump's pattern of misusing the courts to serve political purposes. Ouch. Federal courts have both the inherent power and constitutional obligation to protect their jurisdiction from conduct that impairs their ability to carry out Article III functions. Citing case law here, affirming dismissal because a lawsuit was filed on behalf of vexations litigants. Thus, while a litigant's conduct in other cases would normally not be relevant, when the court is faced with a sanctions motion against a repeat offender, undeterred by admonitions, it has the authority to consider that litigant's outside conduct. Citing the Johnson case, finding district court had inherent power to investigate the scope and extent of the litigant's misconduct that threatened the integrity of the court. Citing also rejecting a plaintiff's sanctions appeal in part because the district court conducted a comprehensive examination of plaintiff's litigation history, cited dozens of plaintiff's past cases, concluded that only 2 had merit, and provided examples of past cases where plaintiffs followed an abusive strategy similar to that employed in this case. Yikes. You don't want to get on the wrong side of the judge here with stuff like this. This is pretty bad. So this is the one that is just absolutely ludicrous. I mean, it's all ludicrous, but this one's really ludicrous. Hello, good to see you, Counselor Cat Mom. A Trump versus Pulitzer board. All right, this is true. This is actually written in a court order. On November 15th of 2021, on behalf of Mr. Trump, Ms. Haba demanded the Pulitzer Prize Board take immediate steps to strip the New York Times and Washington Post of the 2018 Pulitzer Prize for national reporting. Let's bump down and see. We have a demand letter from Alina Haba, lawyer for former President Trump, to Bud Clement, interim administrator here. So he's citing a demand letter. Bumping back up, by correspondence styled demand letter, notice of potential litigation and non-spoilation of evidence. She threatened prompt legal action should the prize not be withdrawn. Seriously, yes. Can you believe it, Murray? He sued to get the Pulitzer Prize taken away from the New York Times and the Washington Post. Then, on May 27th, Mr. Trump wrote stating, I again call on you to rescind the prize you awarded on blatantly fake, derogatory, and defamatory news. If you choose not to do so, we shall see you in court. Again, another letter from Donald J. Trump to Ms. Miller, an administrator of the Pulitzer Prize. And then we've cited where that letter is. On October 13th of 2022, Weber, Crabb, and Wien, PA, another law firm representing Mr. Trump, wrote again, threatening suit, claiming that in refusing to rescind the award, the board and its members acted not only with reckless disregard for the truth, but with authentic animosity and malice towards President Trump and the desire to cause him true harm. As such, according to these lawyers, the members of the board are individually liable for damages, including punitive damages for defamation. Punitive damages are those huge multi-million-dollar damages. And then we're bumping down here. This is a letter from Byrd and Bailey, lawyers for Trump, to Ms. Miller, again, the administrator for the Pulitzer Prize Board. Can you believe that? That's so much. That's just a lot, isn't it? Let's just take a moment to acknowledge what's happening in this situation, because that's a lot. So let's see what happened to the to the situation with the Pulitzer Prize. A little over a week later, Mr. Trump, at a rally in Robstown, Texas, held on October 22nd of 2022, announced, "Within the next 2 weeks, we're suing the Pulitzer Organization to have those prizes taken back." Again, we're citing down here an article, "Trump doubles down on threats to sue Pulitzer Board at Texas rally." Oh my gosh. On December 13th of 2022, Mr. Trump followed up on his threat by filing a lawsuit in a state court in, oh my goodness, Okeechobee? Okeechobee. Okeechobee? I'm sorry, I can't. What is that? Okeechobee. Okeechobee, Florida. In Florida, a location with no apparent connection to Mr. Oh, wait. Okeechobee. Okay, thank you. Okeechobee. Okeechobee. Now, hold on. You all are saying something different. Wait a minute. I had it right the first time. Oh, all right. Well, this place in Florida, apparently, it's a location with no apparent connection to Mr. Trump or any of the defendants. Why would he file it there then? That doesn't make any sense. Okay, Chobe. Okay. Okay, Chobe. He sued individually 19 members of the Pulitzer Prize Board. Dang. Alleging defamation by implication. Oh my gosh. That must have been so stressful for those people involved in the Pulitzer Prize Board. Can you imagine getting sued? I mean, with punitive damages. So he's probably putting in the complaint like $57 million. Can you imagine getting that? That'd be so horrendous. Defamation by implication is the concept that literally true statements can be defamatory where they create a false impression. Under the Jews for Jesus case, sorry, that's the name of the case, the Florida Supreme Court explained that if the defendant juxtaposes a series of facts so as to imply a defamatory connection between them or creates a defamatory implication by omitting facts, he may be held responsible for the defamatory implication unless it qualifies as an opinion, even though the particular facts are correct. That's crazy. The complaint, 29 pages, 145 paragraphs, similar to the amended complaint at issue here. Okay, so he's noticing trends. We're watching for patterns. Misrepresents the findings of the Mueller report and the origins of the Operation Crossfire investigation. The alleged defamatory statement reads, A. Statement from the Pulitzer Prize Board. The Pulitzer Prize Board has an established formal process by which complaints against winning entries are carefully reviewed. In the last 3 years, the Pulitzer Board has received inquiries, including from former President Donald Trump, about submissions from the New York Times and the Washington Post on Russian interference in the U.S. elections and its connections to the Trump campaign, submissions that jointly won the 2018 National Reporting Prize. These inquiries prompted the Pulitzer Board to commission 2 independent reviews of the work submitted by those organizations to our national reporting competition. Both reviews were conducted by individuals with no connection to each other. The separate reviews converged in their conclusions that no passages or headlines, contentions, or assertions in any of the winning submissions were discredited by facts that emerged subsequent to the 2018 Pulitzer Prizes in National Reporting Stand. Conferral of the prizes. And then this is out of the Trump v. Pulitzer case. Oh my goodness. All right, I'm taking a minute here to center before we keep moving on, because there's just so much. There's just so much involved. Yeah, this is a lot. I feel bad. I feel bad for him. I mean, no matter who you are, if you're getting a lawsuit after you like that and you don't know what it means, that's horrible. All right, here we go. Let's keep moving on because there's so many more. It has been said that journalism is the first draft of history. And While first use of the phrase is debated, it's often attributed to Philip Graham, the former president and publisher of the Washington Post, from a speech he gave to Newsweek reporters in 1963. So let us today drudge on about our inescapably impossible task of providing every week a first rough draft of history that will never be completed. Okay? The 2018 Pulitzer Award for National Reporting honored the staffs of the New York Times and the Washington Post for deeply sourced, relentlessly reported coverage in the public interest that dramatically furthered the nation's understanding of Russian interference in the 2016 presidential election and its connection to the Trump campaign. The president-elect's transition team and his eventual administration. So here's a quote where citing the New York Times article down here. The effort by Mr. Trump and his lawyers to use the courts to bully journalists as part of a dishonest and futile attempt to rewrite history is a shameless attack on a freedom essential to democracy. Wow. The press serves as a powerful antidote to any abuses of power by government officials and a constitutionally chosen means for keeping officials elected by the people responsible to all of the people who they are selected to serve. Yeah, that's a lot. Wow. I didn't know until I had read this that he had gone after the Pulitzer Prize board. All right, let's take a look at another one. B, Trump versus New York Attorney General, which is very important because, of course, this trial is going in another week. So this is a civil case going against Mr. Trump. In March of 2019, the New York office of the Attorney General, headed by Attorney General Letitia James, began investigating Mr. Trump and his New York businesses. And then down here, the following procedural history and underlying facts are taken from filings in the case, which subsequently ended up before me. So he's just citing the cases already. The amended complaint in that case is a docket entry 19, hereafter referred to as James AC. So the Office of the Attorney General in New York initiated its investigation following congressional testimony by Michael Cohen, a former senior executive of the Trump Organization and special counsel to Mr. Trump, wherein he produced copies of plaintiffs' financial statements that allegedly inflated the value of his assets to obtain favorable loans and insurance coverage, while the Trump Organization simultaneously deflated the value of those same assets to reduce its tax burden. So if anyone wants to know what the New York civil case is about, this judge basically summed it up in 2 sentences. Excellent work, Judge. You did well. That's pretty good. According to Mr. Trump, the Cohen testimony was a pretext to justify the Office of the Attorney General's investigation, and he points to various public statements by A.G. James as support for this theory that the OAG is nothing more than a weapon in A.G. James's arsenal to wage war on Mr. Trump. On August 24th of 2020, the Office of the Attorney General commenced a special proceeding in the New York Supreme Court, New York County, to enforce subpoenas served during the investigation. And we bump down here. The special proceeding is styled People v. the Trump Organization, and then we've got a citation here as well. On February 17th of 2022, Justice Engoron, the state court justice presiding over the special proceeding, denied a motion to quash filed by Mr. Trump and granted the OAG's motion to compel. Again, citing that case, Justice Engoron rejected the Trump respondent's argument that the OAG investigation was based on personal animus and that it amounted to selective prosecution. Let's bump up here. We've got 24. Citing again the respondents being Trump, Ivanka Trump, and Donald Trump Jr. Justice Engoron's order has been affirmed by the state appellate courts in New York. On May 26th of 2022, the February 2022 order was unanimously affirmed by the New York appellate court. The division's first department under People by James v. Trump, finding that the OAG's investigation was lawfully initiated and not selective prosecution. On June 14th of 2022, in a 2-sentence order, the New York Court of Appeals, New York's highest court, dismissed Mr. Trump's appeal. holding that no substantive constitutional question is directly involved. Simultaneously, in December of 2021, Mr. Trump and the Trump Organization sued A.G. James under 42 U.S. Code 1983, which is a civil rights violation, in the United States District Court for the Northern District of New York. Mr. Trump alleged that the OAG's investigation infringed on various of his constitutional rights. As summarized by Judge Sanctions, Mr. Trump and the organization asserted that A.G. James, 1, violated their 14th Amendment due process rights by commencing investigations against the plaintiffs in bad faith and without a legally sufficient basis. 2, violated their First Amendment rights by seeking to stifle plaintiffs' free speech and retaliate against plaintiffs based upon Mr. Trump's political views. And 3, violated their Fourth Amendment rights by issuing subpoenas without any justifiable legal or factual basis. And 4, abused process to advance her own political career and injure Mr. Trump personally and political. That's a lot. That's a lot of constitutional claims against that AG. That's quite a bit. I don't think we really understand how much she has really gone through in going forward on this civil case in New York, just as a quick side note. So Judge Sanctions granted A.G. James's motion to dismiss pursuant to Federal Rule of Criminal Procedure 12b1 on grounds of younger abstention, and stated that in the alternate, the case would be dismissed under Rule 12b6 because of res judicata, meaning it was already done. Res judicata means the case had already been decided. The court also noticed that plaintiff's assertion that A.G. James conducted a baseless fishing expedition and knowingly advanced claims that were unwarranted under existing law are wholly unsupported. Mr. Trump has appealed to the Second Circuit. Oh my gosh. On September 21st of 2022, following its investigation, the OAG commenced an enforcement action pursuant to New York law. On November 14th of 2022, following a granting of the OAG's motion for a preliminary injunction, Justice Ingren appointed the Honorable Barbara Jones, a retired federal judge, to serve as monitor of the Trump Organization. Mr. Trump appealed to the New York Appellate Division's First Department, where it remains pending. My goodness, there's so much. Wow, this is so much. I can't even imagine what it would be like to have so many things filed. Yeah, so Miss James, or A.G. James out of New York, is doing just amazing work with the level of this on her shoulders. Then on November 2nd of 2022, Mr. Trump filed a lawsuit against A.G. James in Florida State Court. Okay, here we go again. The Circuit Court of the 15th Judicial Circuit for Palm Beach County, Florida. The following day, he posted the following on Truth Social. I thought I'd heard it all. Yeah, me too. Yeah. Oh, statement by Donald J. Trump, 45th President of the United States. This again is a Truth Social post. A puppet judge, oh, rude, of the New York Attorney General. She's elected. Isn't that an elected position? And other sworn enemies of the president. Wow, I'm sorry, I'm going to need to reread that. That's a lot in just like those 10 words. That's a lot. A puppet judge of the New York Attorney General and other sworn enemies of President Trump and the Republican Party has just issued a ruling never before seen anywhere in America. It's communism come to our shores. What? Businesses will be fleeing New York. What? Which they already are for other states and other countries. Today's ridiculous ruling by a politically motivated hand-picked judge makes it even more vital for courts in both New York and Florida to do the right thing and stop this inquisition. This is awful. This is terrible. So this is the Honorable Barbara Jones, a retired federal judge, is serving to monitor the organization, and he's saying these things. Wow. We have to fight back against the radical tyranny and save our country. Oh my gosh. And then we're citing the Truth Social post. That's really terrible. Sworn enemy. Yeah, this is awful. But I mean, it's illustrating the judge's point, though, isn't it? That he's using the courts as a way to harm his political adversaries. On November 14th of 2022, plaintiff filed an amended complaint and an emergency motion for temporary injunction. Plaintiff brought 3 counts against defendant individually. Count 1 is brought under the civil rights violation for various constitutional violations. Count 2 alleges violations for plaintiff's rights to privacy and property under Florida law. Count 3 alleges violations of plaintiff's rights as grantor and beneficiary of the trust. In his emergency motion, plaintiff requested a temporary injunction against defendant, either personally through an agent or through any other person acting in active concert or participation with her, from requesting, demanding, possessing, or disclosing the 2020 or 2022 amendments of plaintiff's trust. On November 16th of 2022, defendant removed the case to this court, where it's now pending before me. That's not a good sign. That's not really a good sign here for Trump. This judge is not very happy about this situation. The James A.C. copies verbatim substantial portions of the dismissed New York federal action. It begins with provocative rhetoric, all too familiar. Whoa, he's just cutting and pasting his different petitions. Whoa. Extraordinary wrongdoing requires extraordinary relief. As set forth below, James has repeatedly abused her position as Attorney General for the state of New York to pursue a vendetta against President Trump, a resident of Palm Beach County, Florida, with the stated goal of destroying him personally, financially, and politically. Suffice it to say, these actions are contrary to both the Constitution and the laws of New York and Florida and the United States Constitution. Wow. Yeah, it's all copy and paste. I think you're right. It's a lot. On December 21st of 2022, I denied the emergency motion for temporary injunction, finding that none of the prerequisites for the injunction were met. I found that plaintiff's attempt to sidestep rulings by the New York courts by suing A.G. James individually rather than in her official capacity was plainly frivolous. Yes, he can, Karen. He can use his campaign donations. I found there was no likelihood of success on the merits, no irreparable harm, and to impede a civil enforcement action by the New York Attorney General would be unprecedented and contrary to the interests of the people of New York. I urged Mr. Trump and his lawyers to reconsider their opposition to A.G. James's motion to dismiss, because this litigation has all the telltale signs of being both vexatious and frivolous, which are 2 ways you can get a bad faith claim against you as a lawyer. All right, so there we go. So there's Miss James. So now we've got the Pulitzer Prize board and we have Miss James. So next we'll get into Twitter. Thank you very much. If you will please just hold on for one moment. I need to grab my backup battery pack. So just one moment, please. Hydrate. Yes, I will. I will hydrate. All right, one moment here. This is going to take 1 second here. Here we go. We're back. Oh my gosh. Yes. Okay. Okay, here we go. Back into it. This order is just so good, you know? You just have to get through it. It's so good. It has just so many amazing points. All right, let me just make sure I'm centered here before I dive back in. This is Trump versus Hillary Clinton. And this is the, let me get the first page out here. Here we go. I'll just put this first page back up to the left a little. Sure. There we go. How's that? Yes, so we've got an order for sanctions here, is what I'm reading through right now. Yep. You got it. Okay, so here's the case. I will go ahead and dive on back in. Yes, thank you. You got it. Yeah, it is. It's both of those things, I think. It's accurate. Very accurate. All right, so Trump versus Twitter. So we went through the Pulitzer Prize board. We went through Miss James. Oh, thank you. And now we are on to Twitter. Let's see about the lawsuit there. Yes, he's justifying the sanction. It's a significant sanction. And I mean, he's building something here. He's building precedent, and he's doing a really good job of it. All right, on July 7th of 2021, Mr. Trump, Linda Quadros, and the American Conservative Union, individually and on behalf of the class, sued Twitter and Jack Dorsey. The complaint was filed in U.S. District Court in the Southern District of Florida. The case was, and again, we are citing the case here. Let's bump down. The same day, Mr. Trump also sued YouTube, Sundar Pichai, the chief executive officer of Google and Alphabet, Facebook, and his chief executive officer, Mark Zuckerberg. Both of these cases were transferred to the Northern District of California. Okay, so everybody was getting sued. Let's just make sure we know that. The case was subsequently transferred to the Northern District of California pursuant to Twitter's forum selection clause. That's a lot of places. So Google, YouTube, everybody was getting sued. Shortly after announcing the lawsuits, Mr. Trump started sending breaking news alert text messages directly to his followers, including a link that asked them to donate to his Save America PAC, so his Political Action Committee. Let's bump down here to the text messages. The text message read, President Trump, I'm suing Facebook and Twitter for unconstitutional censorship for a short time, 5 times impact on all gifts. What does that mean? What? 5 times impact on all gifts? Donate now. The link in the text message brought recipients to a dynamic website prompting them with the above request for donations. Okay, that's where his funding came from. Yeah, while the website has since changed, it has been documented in other places. Trump announces lawsuits against Facebook and Twitter, immediately starts fundraising. Business Insider cited. Whoa. If you donate enough, you get... Really? Okay. Wow, so that was right after he filed his lawsuit against Twitter. That's interesting. All right. So... President Trump's filing a lawsuit, right? Facebook unfair. Please contribute immediately your impact to 500% and to get your name on the donor list President Trump sees. So your name is put on a list that he sees? So wait, let me just make sure I get this right. Okay, filing a lawsuit against Facebook and Twitter for unfair censorship. For the next hour, we've activated a 5 times impact on all gifts. Please contribute immediately to increase your impact to 500% to get your name on a donor list President Trump sees. So he's just going to see the list. So you just get your name on a list? What? Okay, whatever. I don't know strategies about that stuff. I don't get it. Whatever. All right, and then here we bump down to 28, showing a tweet from a Twitter user. including screenshots of the text message and donation websites. Emphasis in the original. All right. That seems like, I don't know. What am I thinking of? Like those big, those big, huge churches that ask for donations. Is it like that? Is that what I'm thinking of? A little bit like that when they're like, oh, send money in now. Is that kind of it? Yeah, I don't know. I don't know what it has to do with anything. All right. So we'll keep moving. I'll keep on trucking here. Yeah, the mega church. I mean, don't they? I don't know. I mean, I don't want to be negative towards anybody, but I mean, don't they do stuff like that when they're trying to get donations? So he knows who to. Yeah, I know. Right. It's legal as long as it's registered and in the line with the campaign. Absolutely legal. You got it. Okay, you got it. And I'm not saying there's anything wrong with that. I'm just trying to find something similar is all. So. No, not trying to judge. No judging here. All right, D, Trump versus CNN. Now, if many of you have been with me for a while, I did go through this case. Actually, it was a fascinating case. But this was another case here. On October 16th of 2019, Charles Harder, as litigation counsel for President Donald J. Trump and Donald J. Trump for President Incorporated, advised CNN that my clients intend to file legal action against you to seek compensatory damages, treble damages, punitive damages, injunctive relief, reimbursement of legal costs, and all other available legal and equitable remedies to the maximum extent permitted by law. All right, so this is a demand letter sent to CNN, okay? So, please center. Yes. Here we go. Hold on. How am I doing? How's that? Is that better? Is there anyone he hasn't sued? I don't know. It seems like he sued everybody. To the left. Oh no, I'm starting to sing. It's getting late. Here we go. How's that? Better? Still more to the left. Half an inch to the left. Okay, pretty soon you're going to start saying to the right. More more to the left. It's fine. Okay. Uh-oh. I'm going to keep moving it. Stop. Okay, is it good? Okay. All right. Okay, thank you. Thank you, everybody. I must have knocked my camera, I think. All right, here we go. So, yeah, he's suing everybody. Everybody's getting sued. Oh, my goodness. All right, so here we go. Yes, to the left. All right, so claiming violations of the Lanham Act because of misrepresentations to the public, to your advertisers and others, the letters claimed, never in the history of this country has a president been the subject of such a sustained barrage of unfair, unfounded, unethical, and unlawful attacks. I don't know, I think I could think of a couple of other presidents that had more difficult times. I'm just going to put that out there. On March 6th of 2020, represented by Mr. Harder, Donald J. Trump for President Incorporated sued CNN for libel based on an article by a contributor entered, soliciting dirt on your opponents from a foreign government is a crime. Mueller should have charged Trump campaign officials with it. The district court found the complaint did not adequately plead actual malice and dismissed it with leave to amend no later than November 30th of 2020. Yeah, I think Kennedy did have worse days. I would agree with that statement wholeheartedly. I can get behind that. Okay, I'm trying to be extremely careful to not get off of my center here. Here we go. I'm trying to get exactly back. There we go. All right. Plaintiff's counsel subsequently advised that an amended complaint would not be filed. So on December 31st of 2020, the case was dismissed without prejudice for failure to comply with the court's order. Mr. Trump then began fundraising for another lawsuit against CNN, issuing the following appeal. To the right. No, not to the right. No. Oh my goodness. It's all falling apart. Okay. All right. Is this good? I can't. All right. Lock it there. Locking it in. All right. Hold on, everybody. I'm now extremely nervous. Okay. I'm going to get it. Hold on. Here we go. I'm going to set this up. I have my folder here and everything, but for some reason it's still just not quite working. All right, there we go. We should be in place. All right. So here's the next appeal. I'm calling on my best and most dedicated supporters to add their names to stand with me in my impending lawsuit against fake news CNN. Add your name immediately to show your support for my upcoming lawsuit against fake news CNN. Wow. Okay, 31 down here. And this is an article saying Trump begs supporters for donations towards upcoming CNN lawsuit, Yahoo News. Wow. All right. So here we go. On October 3rd of 2022, Mr. Trump sued CNN for defamation per se, count 1, and defamation count 2. While claiming to meet the actual malice standard of New York Times versus Sullivan, Mr. Trump's lawyers argue it does not and should not apply where the defendant is not publishing statements to foster debate, critical thinking, or the unfettered interchange of ideas, but rather seeks to participate in the political arena by offering propaganda. Ooh, that's harsh. Less than 24 hours later, a fundraising email from Mr. Trump proclaimed, "I'm suing the corrupt news network, CNN, for defaming and slandering my name." Supporters were encouraged to contribute $5 or more. And that bumps us down to Trump uses CNN lawsuit to raise money. All right. To be clear, the sanction in this case is not imposed against Mr. Trump for the Pulitzer, Twitter, or CNN litigation. Those cases are before other judges who will make their own determination. And a decision in Mr. Trump's Florida lawsuit against the New York Attorney General, a case now pending before me, is immature. However, this widespread and persistent conduct points to the need for deterrence in this case and helps explain why Rule 11, Section 1927 and the Defend Trade Secrets Act are not up to the task. This is purposeful conduct, some of which occurs beyond the pleadings and even outside of the courtroom. It was a wrong against the institutions set up to protect and safeguard the public. Mr. Trump's deliberate use of a frivolous lawsuit for an improper purpose constitutes bad faith, and the behavior is not unique, but part of a plan, at least a playbook. The telltale signs: provocation and boastful rhetoric, a political narrative carried over from rallies, attacks on political opponents and the news media, disregard for legal principles and precedent, and fundraising and payments to lawyers from political action committees. Ooh. Wow, it's all coming out now, isn't it? Mr. Trump's Save America PAC has spent $9.7 million in legal bills since 2021, according to the Washington Post review. Wow, that's a lot. Over $2 million has reportedly been paid to Miss Haba Levitt. Cassidy Hutchinson transcript reveals new low for Trump world. And Miss Haba, in addition to her role as lawyer, has become a senior advisor for Mr. Trump's new MAGA Political Action Committee. According to a MAGA Incorporated spokesperson, whether it's on legal matters or political issues, she's more than capable to represent President Trump in a variety of venues. Citing the Washington Examiner. Wow, that's like a lot. She said, yeah, I said millions. The Trump Save America PAC has spent $9.7 million in legal bills since 2021. And this was of January of 2023. This was before his criminal cases were filed. This was before the New York criminal case was filed. Wow. $2 million of that's been given to his attorney. That's a lot. Yeah. Whew. All right. So, and when a ruling is adverse, accusations of bias on parts of the judge, often while the litigation's ongoing. So he's going after the judges during the ongoing litigation is also being cited here. Yikes. I don't know how that would be appropriate in any situation. All right. But legal trials are not like elections to be won through the use of meeting hall and radio in the newspaper. What's radio? Frivolous lawsuits should not be used as a vehicle for fundraising or fodder for rallies on social media. Mr. Trump is using the courts as a stage set for political theater or grievance. This behavior interferes with the ability of the judiciary to perform its constitutional duty. Consequences. Number 4. Having determined that sanctions are appropriate under inherent authority, I must now determine what those sanctions should be. I find that an award of defendants' attorneys' fees and costs is a fair and just sanction, given plaintiffs and his counsel's actions in this case. What follows then is an analysis of what amount of fees and costs is reasonable. Remanding imposition of sanctions for proof of incurred fees and expenses to determine reasonableness. Wow, this order is really tight. He is very careful about this. A, defendant's fee application and plaintiff's objections. Before analyzing the reasonableness of defendant's fees request, I will briefly explain what materials I considered in reaching my conclusions. A fee applicant bears the burden of providing an adequate application, but the opposing party must raise clear objections for a court to rule on them. Citing the American Civil Liberties Union, objections and proof from fee opponents concerning hours that should be excluded must be specific and reasonably precise. Defendants request $1 million, $58,283.50. You got to get that 50 cents in there. That's serious. Okay. In fees and costs. So that's their joint motion. That's what they're asking for in fees. The application is a 304-page document filed in support of defendant's fee request. The application contains 11 exhibits in support of the requested fees for each set of lawyers, law firms representing, some jointly, the defendants in this case. Each exhibit contains 1, a declaration attesting to the authenticity of the hours and rates billed, with a corresponding summary of fees based on the stages of the case. 2, background information on each timekeeper that describes professional experience and credentials. And 3, just one moment. There we go. Time entries. In response, plaintiff filed largely indecipherable objections. So let's just see here. In response, plaintiff filed largely indecipherable objections. I will highlight just a few of those issues. First, plaintiff's objections relied on unsigned draft of the application. So he's saying the draft of the application was unsigned, with application at 255 containing Mr. Tyrrell's signature. This was significant not just because it was unsigned, but because some of the calculations changed from the draft to the final application. Comparing objections at 273. Ms. Lett's declaration stating total fees under Chart C as $5,650 with application at 285, and so on. Plaintiff's corrected objections were equally unhelpful. First, plaintiff still relies on certain draft portions of the application. Compare the corrected objection at 307 with application at 285. So he's going through specifics here on the objections to the claim. I'm not going to spend too much time going through that because we still have a lot more to get through. But he's basically, the plaintiff is saying, that they screwed up how they wrote out their billing. These errors, taken as a whole, render the entire document unreadable. So I considered whether to offer the plaintiff yet another opportunity to cure his objections. So he's saying that the plaintiff's pieces saying that they're wrong, things that are wrong, is messed up. And he's saying, should I give him another chance? But without a motion, however, I did not find it to be a fair exercise of this court's discretion. So he's not allowing the plaintiff to go back and fix these objections that he's setting out that are ridiculous. In almost every area of the law, a party waives an objection for failing to properly raise it. So too here. Thus, to the extent the plaintiff's objections were not clearly identifiable, I did not consider them. So the objections were viewed as improper. All of the objections to the defendant's fees that were set out. Reasonableness of fees. Of the total request of fees and costs, the $1,058,283.50, $14,292.39 were costs incurred by electronic legal research and $600 in pro hoc vice filing fees. Plaintiff does not object to either. Let's bump down here. Plaintiff appears to object without explanation to defendant Danchenko's costs incurred for electronic legal research of $6,389 as vague. This is nonsensical and likely a mistake. Vague is used by the plaintiff everywhere else in his corrected objections referred to vague time entries. More on this below. Nowhere else does plaintiff raise a vague objection for costs incurred for electronic legal research, which are typically bare bones receipts. I will overrule the objection as I can discern no basis for it. Well, that's pretty clear. Filing fees are taxable costs under 28 U.S.C. 1920. However, consistent with the finding of other courts in the circuit and other circuit court costs incurred for electronic legal research are considered a component of attorney's fees rather than costs under 28 U.S.C. 1920. I find the award of $14,292.39 for electronic legal research reasonable given plaintiff's lack of objection and the sprawling nature of his claims, which, while frivolous, were numerous enough to necessitate substantial legal research. So he's basically saying that the defendant should be paid for the amount of legal research that they had to do in order to double check and make sure that the frivolity was indeed frivolous. So it's a lot. The starting point in any determination for an objective estimate of value of a lawyer's services is to multiply hours reasonably expended by a reasonable hourly rate. Now he's going through and explaining hourly rates here. An hourly rate. A reasonable hourly rate is prevailing market rate in the relevant legal community for similar services by lawyers of a reasonably comparable skill set, experience, and reputation. So he's just going through to calculate how he came up with the legally hourly rate to the left. Okay. I trust you, M. Kelly. I trust you there. I'm going to keep my eyes on you, M. Kelly. You're the one that's helping me here with that. So he's going through again and explaining this hourly rate. How is that? Is that better? Overpriced? Perhaps, but there were like a whole bunch of people. Almost all the defendant's attorneys seek substantially discounted rates, ranging from 28% to 66% less than the rates actually billed. Wow, because they're using a sliding scale. Thank you very much, MK. On a sliding scale based on expertise, defendants' attorneys seeks rates ranging from $255 to $800 for lawyers and $120 to $150 for paralegals. Plaintiff objects to the total amount as unreasonable or excessive, but he limits those objections to purported deficiencies in billing judgment. More on that below. Nowhere in his response in opposition or dozens of pages of line-by-line objections does defendant challenge the rate charged by the defendant's attorneys. Defendant Joff's attorneys and paralegals are the only ones not to have discounted their rates. Defendant Joff's lead attorney, Mr. Tyrell, seeks his ordinary non-local rates on the grounds that he qualifies for an exception applicable to attorneys with extensive prior experience with a particular factual situation. Citing case law here, while plaintiff does not object, I refuse to apply Barnes's exception where it is not obvious that defendant Joff's attorneys provided any significant gains in efficiencies. So again, he's comparing out whether or not the hourly rate was appropriate for each attorney. Moreover, Mr. Tyrell's declaration, application at 251, speaks to his purported prior knowledge, not that of defendant Joff's other attorneys, paralegals who also seek their non-local rates. Accordingly, in considering the Johnson factors, the discounted rate of the other attorneys in this case, in my own experience, I will discount defendant Joff's attorneys and paralegal fees. So he's even discounted the rates. That's pretty nice. I find the rest of the rates charged by the defendant's attorneys to be reasonable. In reaching this conclusion, I considered my own experience, the Johnson factors, and what reasonably comparable attorneys in similar cases in the legal community might be expected to charge. Plaintiff's lack of objection further supports the reasonableness of the rates. Given that there are dozens of attorneys, I will refrain from explaining my reasoning for each and every one of them. Dozens of attorneys, dang. Although I've considered them all. In reference to the Johnson factors, I consider the complexity of the allegations leveled by the plaintiff and the skill it required to succinctly respond to each allegation with well-reasoned arguments. In my view, this case required excellent lawyering to defend against the overwhelming number of convoluted allegations and frivolous claims raised by the plaintiff. Harsh. Indeed, these lawyers are some of the best in the country and accordingly charge top dollar as evidenced by rates actually paid by the defendants. In their ranks are litigators who have argued and won several cases before the U.S. Supreme Court, served in positions of great significance in government, graduated from and taught at prestigious law schools, clerked in federal district courts, circuit courts, and U.S. Supreme Court, and obtained victories for their clients to the tune of billions of dollars. Having set reasonable rates for the lawyers involved, I now move on to evaluating the time they spent on the work in this case. So I think this is actually really good to see how much work it takes for an attorney to combat frivolousness when it comes to these kinds of constant filings in these cases. Okay, hours reasonably expended. So let's go through and see how much time was used in fighting this kind of a case. And keep this in mind as we go through all of his lawsuits. So in determining the number of hours reasonably expended, the Supreme Court requires fee applicants to exercise billing judgment. Therefore, attorneys should make a good faith effort to exclude from a fee request hours that are excessive, redundant, or otherwise unnecessary. This must necessarily mean that the hours excluded are those that would be unreasonable to bill to a client and therefore to one's adversary, irrespective of the skill, reputation, experience of counsel. Redundant hours generally occur when more than one attorney represents a client, but in such cases, attorneys may still be compensated if they are not unreasonably doing the same work. Whereas is the case here, fee documentation is voluminous. An hour-by-hour review is simply impractical and a waste of judicial resources. Explaining in this case that trial courts should not become green eyeshade accountants. Green eyeshade, come on. The essential goal in shifting fees to either party is to do rough justice, not to achieve auditing perfection. So trial courts may take into account their overall sense of a suit. What would be an example of redundancies in a case like this? I'm not exactly sure. I think anytime you've got redundancies on fee charges, is anyone here in the comments doing any of their billable hours for their attorneys, how they do them? As an accountant, I can say, ouch. Yeah, the green eye shade, that just is another way of, it's what accountants used to wear. It's very old school, very detailed. Yeah, so the redundancy would be, does anyone have any examples they can give us? I don't do billable hours yet. Fair enough, Tiffany, fair enough. So I would assume in this particular case, when they're excessive, redundant, or otherwise unnecessary. So let's just say an average attorney would take 2 hours researching something, but this particular situation, they're saying it took me 6 hours. So rather than doing 2 hours, they're being redundant. They're saying I had to super research this particular issue as opposed to just doing the normal 2 hours. So, by being super extra careful, spending 6 hours researching rather than 2 hours would be probably a most classic example. Your rates are separate? Excellent. I thought it was blue. Is that when two lawyers are both doing research? That could also be it too. Yeah, when we've got two attorneys researching the same thing, and maybe you only need one attorney doing it. Although I think a lot of that's going to be, again, just the amount of research that you're doing on the same exact issue. So it's kind of like you've got to hit your issue when you're done researching it and move on rather than continuing to go down the rabbit hole. All right, so trial courts may take into account their overall sense of a suit and may use estimates in calculating and allocating an attorney's time. And appellate courts must give substantial deference to those determinations in light of the district court's superior understanding of the litigation. Notwithstanding, I'm mindful of this court's obligation to produce an order on attorney's fees that allows for a meaningful review. Here, the fee documentation is certainly voluminous. Though more than $200,000 the movement seeks in attorney's fees is an indication enough that this case is voluminous. And it is voluminous. We have a lot of that. Defendant's application seeks over $1 million in fees, 304 pages long, and includes hundreds of time entries by dozens of lawyers. In response, plaintiff raised line-by-line objections by way of tables at the end of each exhibit. The tables, while not descriptive in any meaningful way, do identify objected to entries under the following categories: block billing, duplicate, excessive, vague, and clerical. Accordingly, I will balance the aforementioned competing directives not to attempt auditing perfection, yet still allow for meaningful review by analyzing a mostly random selection of plaintiff's billing judgment objections under each of his categories. The entries excerpted below serve as a representative sample of the entries that I examined and reasoning applied therein. Objections. Block billing. Plaintiff objected to block billing are largely overblown. It's true lawyers should avoid block billing, i.e. blocking for several tasks in the same time entry. To, or at least in this context, allow a court to ascertain the number of hours reasonably expended per task. This can be a problem because if you're hopping around from issue to issue to issue, a lot of times you can research and then also do writing at the same time. So research, writing, and putting together whatever motions you're working on, all of those things you can be hopping around. And so you would put them all into one block of time. So what they're saying here is they're saying these different tasks alone would have taken less time than if you had put them all stacked up into a block, is what they're saying here. The degree of block billing identified by plaintiff simply does not rise to the level that merits an across-the-board cut in hours. However, I am inclined to cut back in individual cases if the block billing spanned several hours and included numerous tasks. The records often lump together all tasks performed by an attorney on a given day without breaking out the time spent on each task. Right, because you can see how that would work, right? If we spend a couple of hours researching and we get an idea, and so we go and type up a few paragraphs in our brief, and then we go back to researching, we can kind of ping pong back and forth. So it can be difficult to figure out exactly what we're spending our time on. We just have to be really careful about that when we're doing billable hours. By way of example, plaintiff objects to the following entries for block billing. So we've got some examples here that should help us. Here we go. Number 1, review and revise defendant's draft reply brief, review Trump's opposition brief, emails regarding draft reply brief. So what they're doing is they're blocking out and they're saying this took 3.9 hours to do all these tasks. Next, reviewing Trump amended complaint, reviewing previous motions, practice, review draft portion or motion to dismiss Trump amended complaint, discussion with A regarding draft motion, and that took 5 hours. Next, confer and strategize via email, telephone with counsel regarding case, initial appearances, local rules, and complaint, review draft motion to dismiss, draft and file pro hoc motions, review and file a response to motion to expedite 15 hours. I was going to say that better be a huge amount of hours because that's a lot of work. That's a lot of work all in one big block here. So what's boop boop? Yes, boop boop. Take a moment. It just means to tap your screen. It's from a previous live we had with the phrase boop boop was used a lot. So, oh my goodness. All right, here we go. Thank you. Yes, let's explain our booping. Thanks all for the boop boops. Appreciate it. The first 2 examples do not merit a reduction in hours. The second toes the line, but I find that even if the timekeeper had entered those times separately, 5 hours would nonetheless be reasonable. The same reasoning applies to the first example and to all other objections for block billing that I looked at. The third, however, is a sort of block billing that requires a reduction in hours because it's impossible for the court to accurately divvy up the time per task in a reasonable manner. Yeah, this is a lot. That's a lot to put all in one block. The timekeeper for this entry is attorney Marcus. A closer look at his time entries reveal a similar pattern. So he's just saying that this seems to be this attorney's style. I note, however, that as local counsel, his role was not as susceptible to itemized billing and his total hours were not substantial, but I will cut his hours down by 15%. So that makes sense. That seems reasonable. And duplicative. I will be going through the indictment, the Bob Menendez indictment. Not tonight, but I will be going through that for sure. It's fascinating too. Okay, duplicative. Plaintiff's objections for duplicative time entries are not presented in a way that allows this court to properly review and analyze them. Plaintiff's table, oh, lemon, love the lemonade. Plaintiff's table simply points out entries that he believes are duplicative, but does not say what is duplicates. That's kind of important. You kind of need to have that. Instead, plaintiff leaves it up to the court to piece together a cogent series of objections. I refuse to do so. Good for you, Judge. Wow, that's a lot of work for the judge to do. But even when I reviewed the relevant time entries with an eye for duplicative billing, I did not find any unreasonable billing that merits a cut in hours. So that makes sense. Excessive. Plaintiff objects to, among other things, the following time entries as excessive. So, review draft of the DNC motion to dismiss brief and share with RAC for final review, 2.3 hours. Reviewing amended complaint, reviewing editing draft brief, 5.5 hours. Review and revise motion to dismiss brief regarding Trump lawsuit, emails to and from, 2.9 hours. Plaintiff's objections are unconvincing. It's no surprise that these lawyers, when responding to such an egregious example of shotgun pleadings and subsequent opposition, had to spend numerous hours thoroughly analyzing the allegations and crafting exhaustive responses. I found these time entries and others like it reasonable. Number 4, vague. The general subject matter of the time expenditures ought to be set out with sufficient particularity so that the district court can assess the time claimed for each activity. Notwithstanding, the court can rely on its own knowledge and experience and may form an independent judgment when determining the reasonableness of fees. Plaintiff objects to the following time entries as vague. Reviewing complaint and continued revisions to redacted for 4.5 hours. Research redacted. Well, sometimes that's just what we're doing. Sometimes we're just doing reviewing, researching. Sometimes we just have to write down research. It's not that bad. Number 3, miscellaneous communications, including with client and other counsel regarding status of matter, ongoing coordination and related matters, review and analyze materials regarding the same. 1.4 hours. That's actually a lot of stuff for 1.4 hours. The first and third time entries provide sufficient detail to overcome an objection for being vague. The same is true for almost all the other time entries viewed under this category. Only the second time entries rises to the level of being vague. The timekeeper for the second entry is Attorney Turner. A closer look at her time entries reveals a similar pattern. While I find Attorney Turner's total hours to be relatively low, I will cut her hours by 15% to account for the handful of vague entries. This is amazing. Yeah, the judge should charge for his hours lost too. I know, this is a lot. This judge really took a lot of time and consideration here. Clerical. Consistent with the idea that the hours excluded are those that would be unreasonable to bill to a client and therefore to one's adversary, irrespective of the skill, reputation, and experience of counsel, lawyers should not, in the interest of reducing fees, bill their clients for clerical work that a non-lawyer could just as well do. It appears the plaintiff's only objection under the category of clerical, totaling $390, is for work done by Miss Dietrich, the senior case manager, a role akin to a paralegal. Miss Dietrich's hourly rate is $150, a reasonable rate for paralegals. Billing a client for clerical work done by a non-lawyer related to this case is completely reasonable and expected. Okay, so that seems reasonable. And we are getting to the conclusion. We're coming down to the conclusion here. Adjustment of the lodestar. The lodestar in this case is $937,989.39. Having determined the lodestar, the court must next consider the necessity of an adjustment for results obtained. The parties have not argued for an adjustment, and I do not find one to be necessary. All right, hold on just a minute here. Sorry, everybody. There we go. I'm having a battery moment here. Okay, there we go. All right, am I in? Okay. Oh, what's a lodestar? That's just a way of calculating out the fees. So this is when he took out the 15% deductions and accounted for the problems that were vague for him. The judge did, because remember they originally had asked for that $1 million amount. So after he subtracted everything from it, he came up with this. So this is the amount of fees. They fought the Spaceballs to save the princess. Yeah, I don't know why he called it that. I don't know. That's pretty old school, but I mean, it's technically, that's what it is the attorney's fees. Oh my goodness. All right. The court must next consider the necessity of an adjustment for results obtained. The parties have not argued for an adjustment, and I do not find one to be necessary. So he's come up with his number. He's comfortable with the number. Relatedly, however, I find the apportionment of the lodestar is necessary. The amount of fees awarded in this case, while reasonable, is substantial. So it means he's going to kind of divvy it out. As such, joint and several liability, a presumption under Rule 11, but not here, would be inappropriate. The parties that bear the brunt of the responsibility for the sanctionable conduct, plaintiff and his lead attorney, should be jointly and severally liable for the sanction. So not only is the attorney liable, but also Donald Trump himself. So together they need to pay this $1 million essentially. The Rule 11 sanction I imposed on other lawyers in this case is sufficient. Accordingly, plaintiff Donald J. Trump and plaintiff's lead attorney Alina Habba and Habba, Madio and Associates are jointly and severally liable for the total amount. Conclusions. For the foregoing reasons, and having carefully considered the record, the written submission of the parties and applicable law, it's hereby ordered and adjudged that the defendant's joint motion for sanctions is granted. And 2, plaintiff Donald J. Trump and plaintiff's lead attorney Alina Habba and Habba, Madio and Associates are jointly and severally liable for $937,989.39. Signed in chambers at West Palm Beach, Florida, January 19th. Now let's bump down. Sanctions must never be hollow gestures. Their bite must be real. But for a bite to be real, it must be an amount a person can pay. I believe the monetary sanctions imposed here are well within the plaintiff and plaintiff's lawyer's ability to pay, and therefore I have not thought it necessary to conduct an intrusive inquiry into their finances. However, should plaintiff or plaintiff's attorney, plaintiff's lawyer, and law firm believe that the amount would seriously jeopardize their financial status, that individual or firm should file within 10 days of this order under seal a verified statement of net worth, which includes assets and liabilities. In the event of such a filing, the obligation of that individual or law firm will be told until further order of the court. So their obligation to pay would be told if they put in that they have a financial burden. Okay, whew. So that was a lot. That was quite a bit. I think the judge did a pretty good job. I think the judge came in with an acceptable answer to the situation for his motion for sanction. What do we think? Yeah, it's a lot. I mean, that's almost $1 million for filing frivolously. Should be a multiplier on frivolous lawsuits. I agree. We should do that. What was the total? The total was $9,937,989.39 right here. They can afford it. Yeah. Yeah, it's a lot. It's a lot. I mean, it's something though. I mean, for filing a frivolous lawsuit, I don't know that he's even been called out on filing frivolous lawsuits, even though it seems to be his trend. Should also be fined. Yeah, that's a good point. Not too shabby. I think it's something, right? How much did he fundraise? Well, I don't know. I think the footnote that we saw said, what was it? $9.7 million had been spent, but that was before the indictments came down. He's still able, well, yeah. So that takes us then, everybody, that takes us to the most recent order, okay? So this is the order that just came down on the 15th of September. No, he owes Hillary's lawyers, the 39 cents. He owes her attorneys for having to fight this frivolous lawsuit. Now, here's an order. Now, he appealed the sanctions, okay? He appealed and he requested a disqualification of the judge. So here is the judge's response to that. We will get into that. There we go. I should be over. I think he does. Can you read the Hunter indictment? I am not, still more to the left. Okay. How's this? I need my paper spotter. I am not, I guess I'm not prepared to do a full Second Amendment, live. I don't know that I've got the resources for that. So I think I will wait, to do that. Okay. Looks good. Okay, Jen, gotcha. So yeah, I may wait. I need to go, I need to kind of look into that situation first. I'm not against it, but I really don't. I mean, we've got enough battles in our lives that I don't know if we really want to pull in the Second Amendment on top of everything else. Hold on, let me just bump this up a little bit. That might be better. Okay, here we go. How is it? Am I centered now? Am I good, Renee? Okay. I'm relying on you all to let me know. Yes. Okay, we're good. Good. So let's get into this order. We'll talk about the judge now. So we went through all of that. We went through the motion for sanctions. He's got to pay $1 million to the attorneys for the frivolous lawsuit. Trump appealed. He asked for this judge to be disqualified. This is the judge's response. So this will be really good. An order dismissing the motion to disqualify. Here we go. This is just a couple weeks ago. On August 14th of 2023, while an appeal was pending and after the appeal was stayed for the purpose of seeking an indicative ruling for relief from judgment pursuant to Federal Rule of Civil Procedure 62.1, movants filed a motion to disqualify. Given the limited remand by the Court of Appeals, I do not believe I have jurisdiction to consider the motion absent further authorization. Moreover, if the remand permits an indicative ruling, I would not grant the motion and do not believe it raises a substantial issue. Background. On October 11th of 2022, Trump appealed my order of September 8th of 2022, granting the U.S. motions to dismiss all of these defendants here. All right. So we had Dolan, we had Joff, we had Orbis Business Intellect, motions to dismiss, joint motion to dismiss, plaintiff's amended complaint. All of these things here were all dismissed. And entered on November 10th of 2022, a motion to dismiss as well, an order granting that motion. And then we've got the motion for sanctions pursuant to Rule 11. Okay, we just went to that. Finally, on February 6th of 2023, HABA and Donald J. Trump appealed my order dated January 19th, which is what we just went through, okay? Granting sanctions against them. The appeals were consolidated on March 31st of 2023. On June 9th of 2023, the appellants filed their initial brief. On the same day, they filed a motion for judicial notice, or in the alternate, a motion for stay in the Court of Appeals. The appellants asked the Court of Appeals to take notice of a report on matters related to intelligence activities and investigations arising out of the 2016 presidential campaign, the Durham Report, which was publicly released May 12th of 2023. Alternatively, they asked the Court of Appeals to stay all proceedings so the appellants may promptly make a Rule 62-1 motion to the District Court for an indicative ruling concerning relief from the judgment pending appeal. Notably, the appellants did not ask the Court of Appeals to transfer any such motion to another district judge. On July 13th of 2023, the Court of Appeals entered the following order. Appellant's motion for judicial notice or to stay the appeal pending an indicative ruling from the district court is granted to the extent that this court stays this appeal pending appellant seeking an indicative ruling below within 14 days of this order. Appellant is directed to file status reports with this court regarding the proceedings below on the 15th day of each month beginning August 15th. On July 27th of 2023, plaintiff and plaintiff's attorney's motion for indicative ruling based on new evidence was filed. So they basically want a reconsideration of this judge that's already tossed it out and already is given sanctions. They're saying, we've got new evidence because this report came out. We want you to hold on to all of these prior rulings until we can get this evidence out. That's what they're saying. Responses in opposition to the motion were filed by several of the defendants on August 10th of 2023. Then on August 14th, this motion to disqualify was filed. Responses were filed August 28th, and a reply was filed on September 5th. On August 15th, the appellants filed their first status report pursuant to the Court of Appeals July 13th of 2023 order, which while they reported the filing on the motion for indicative ruling and the briefing schedule with respect to that motion, they did not report filing of the motion to disqualify. The appellants have also failed to serve and file a motion to further stay the appeal within 14 days after filing the motion as required by the 11th Circuit Rule 12.1-1. This is the second motion to disqualify filed by the plaintiff. On April 4th of 2022, the plaintiff filed a motion seeking my disqualification because I was appointed to the federal bench by former President Bill Clinton, the spouse of defendant Hillary Clinton. I denied that motion, finding no legal support for his arguments. No appeal was taken from that order. Discussion. Jurisdiction. Upon the filing of appeal, the district court is divested of jurisdiction over the matter. The filing of a notice of appeal is an event of jurisdictional significance. It confers jurisdiction on the Court of Appeals and divests the district court of its control and execution of a judgment that has not been superseded. I don't see how that's a conflict of interest if you're appointed by someone and that person's wife is a defendant. That is not a conflict of interest at all. At all. All right, let me make sure I'm in frame here. Plaintiff's notice of appeal on February 6th divested this court of its jurisdiction over the case. 11th Circuit Rule 12.1 permits district courts to have limited jurisdiction during an appeal only when a party files a motion in the 11th Circuit to stay the appeal until the district court rules on the motion before it. Parties who file motions in district court must, within 14 days after filing the motion, follow these procedures for the district courts have jurisdiction. Plaintiff properly followed these procedures with a motion in the 11th Circuit for a stay to file an indicative ruling on the potential impact of the Durham Report. He did not, however, file a motion to stay the appeal for a motion to disqualify. Further, 14 days have passed since he filed the motion to disqualify, and he has not filed a motion in the 11th Circuit to stay the appeal to allow me to rule on it. As a result, Of plaintiff's partial adherence with these rules, the 11th Circuit only stayed the appeal pending appellant seeking an indicative ruling below. Plaintiff admits in his own briefing that the 11th Circuit issued an order staying the consolidated appeal so that plaintiff and plaintiff's counsel may seek an indicative ruling from this court, and that this court now regains jurisdiction over this case to consider the Durham report in connection with President Trump's amended complaint. Plaintiff made no such procedural showing in his motion to disqualify. Without a full remand from the 11th Circuit, I perceive my jurisdiction to be limited in scope. Appeal dismissed. Okay. Based on the limited scope of the 11th Circuit court order and plaintiff's failure to follow the procedural rules of 12-1, I lack jurisdiction to hear this issue. Here's the merits. If the remand allows for an indicative ruling on the motion to disqualify, I would deny it. The leading case is the Litke versus U.S. case, where Scalia wrote, "First, judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. In and of themselves, i.e., apart from the surrounding comments or accompanying opinion, they cannot possibly show reliance upon an extrajudicial source and can only in the rarest circumstances evidence the degree of favoritism or antagonism required, as discussed below, when no extrajudicial source is involved. Almost invariably, they are proper grounds for appeal, not recusal. Second, opinions formed by the judge on the basis of facts introduced or evidence occurring in the course of the current proceedings or of prior proceedings do not constitute a basis for a bias or partiality motion unless they display a deep-sorted favoritism or antagonism that would make fair judgment impossible." So there you have that, okay? So he's like, no, I'm impartial. What are you talking about? Quoting Judge Jerome Frank, he stated, "Impartiality is not gullibility. Disinterestedness does not mean childlike innocence. If the judge did not form judgments of the actors in those courthouse dramas called trials, he could never render decisions." That's interesting. Of particular resonance here, he also said, also not subject to deprecatory characterization as bias or prejudice are opinions held by judges as a result of what they learned in earlier proceedings. It has long been regarded as normal and proper for a judge to sit in the same case upon its remand. And then we're citing a case again, the Litke case. None of the 11th Circuit decisions cited by movements support disqualifications. So we've got the Bivens case here. So he's just setting out the precedent, saying, I wouldn't be disqualified anyway. First, you didn't plead it properly, but even if you had, I wouldn't be disqualified, is what he's saying here. Movements complained that I went above and beyond the defendant's arguments and conducted extrajudicial research. This seems to be a pejorative misnomer. In my 2 orders on sanctions, I conducted limited independent judicial research. In every instance, in response to arguments made by the parties, I looked at judicial decisions, legal filings, and statements not subject to dispute and directly made by Mr. Trump and his lawyers. In each instance, I cited the source for the information. Sorry, everybody, my voice is starting to go a little bit. From their very first filing, the defendants contended that the case was frivolous and brought an improper purpose. Whatever the utility of plaintiff's complaint as a fundraising tool, a press release, or a list of political grievances, it has no merit as a lawsuit and should be dismissed with prejudice. Now let me bump back again into my endnotes here. So this is from the prior case that he was just talking about on the previous page. We've got number 2 is legal authority for disqualification under this theory. Movement cites 9th Circuit. The facts are different. Drink some water. Oh, yeah, just a minute. Sorry, everybody. Whew, there we go. Okay, I'm just so excited. I'm so excited to find out what happens. I can't. Oh, my goodness. All right. Legal authority for disqualification. The facts are different. A magistrate judge heard the evidence at a bench trial. Lollipop break. Yeah, I'll need one here in a little bit. Took the matter under advisement, then cited a newspaper article discussing the case and the defendant in his decision. The Ninth Circuit held that it was not an abuse of discretion to deny recusal. In deciding sanctions under Rule 11 and under a court's inherent powers, other litigation and conduct outside the courtroom is directly relevant. The 11th Circuit has held that a court has the inherent power to investigate the scope and extent of conduct that threatens the integrity of the administration of justice. So he's saying he does not need to be disqualified under the law, under precedent, and just because he determined sanctions, he did it in a way that was needed and was allowed under precedent as well. Okay, so back into it. We're coming down here to the finish line. Pointing to his litigation against Letitia James, the Attorney General of New York, Twitter, CNN, and New York Times, the defendants described Mr. Trump as a serial litigant who brought cases against his perceived foes for political and fundraising purposes. In their filings, the plaintiff referenced the DOJ Inspector General report and the Crossfire Hurricane investigation, the Mueller report, the indictments of Mr. Dichenko and Mr. Sussman, a letter from John Ratcliffe to Senator Lindsey Graham, and the Justice Department announcement of the appointment of special counsel. I read all the filings and each of the documents. Thank you. Oh, that's so nice of you. I have now also had the opportunity to read the Durham report. Ooh, that's what I wanted to know. Did he read the report? The Letitia James case was filed in state court in Palm Beach County, removed to federal court and assigned to me. In large part, the complaint was copied verbatim from that filed and dismissed in federal court in New York. On that same day it was filed, Mr. Trump posted a statement on Truth Social attacking the New York State Court judge, before whom the civil action in Florida to do the right thing and stop this inquisition. I denied the emergency motion for temporary injunction because none of the prerequisites for the injunction were met. And the attempt to sidestep rulings by the New York courts by suing A.G. James personally was plainly frivolous. I also said that the litigation had all the telltale signs of being both vexatious and frivolous. The CNN and Twitter litigations were filed in the Southern District of Florida and assigned to other judges. In my order, I quoted the fundraising appeals made by Mr. Trump, which accompanied the filings. The Twitter complaint was also relevant to the sanction order because there, Mr. Trump blamed his suspension from Twitter on Democratic members of Congress, Vice President Harris and Michelle Obama. In the amended complaint before me, he said Ms. Clinton was responsible. I also directly quoted the demand letters sent by Mr. Trump's lawyers, his statement announcing the intention to sue, and the complaint filed in state court in Okeechobee. Wait, I had it before. Okeechobee, Florida. Sorry, against the individual members of the Pulitzer Prize Board. Okeechobee. Okay. I can't, everybody. Okeechobee. Okeechobee. I can't. Oh my goodness. Okay, got it. Based upon the arguments of counsel and the work I did, I came to firm conclusions that expressed them carefully. Okay, Chobi. In each of the three orders, different legal standards were applicable to the motions to dismiss and the motions for sanctions. I did not comment on the merits of any undecided case, and where cases have been decided, in whole or in part, I directly quoted from the respective orders. The case before me was frivolous. Its purpose was improper and part of the pattern of behavior harmful to the rule of law. Article 3 judges have an obligation to protect the administration of justice from abuse. Conclusion. For the reasons stated above, the motion to disqualify is dismissed for lack of jurisdiction. If the remand allows for indicative ruling, I would deny the motion. Signed in chambers by Judge Middlebrooks. There we have it, everybody. We made it. Boy, this Judge Middlebrooks is quite the judge. I am very impressed by him. Help me, Obi-Wan Kenobi. No. I will be in my head now forever. Forever. Yeah, he's pretty amazing. It was fantastic how he went through and explained every single penny, literally every penny. Yes. Yeah, I like this judge too. I'm with you. I really do. Yeah, Middlebrooks, he did a great job. No, it's fine, Deborah. It's okay. Yes. Oh, you're welcome. Yeah. Now, I mean, it's fascinating though, isn't it? So he put out this order for sanctions in January, and then Trump appealed, and everything's continuing to be appealed repeatedly over and over and over again, and asking for disqualification. So it's, this judge is like, look, I've had enough. This is, yeah, Mimi, exactly. The judge was very thorough. Okie beep, okie boop boop. Forever now. Okie, okaboji. I want to say okie minoji. Oh, can you read it over again? You're hilarious, Mr. Incognito. Hilarious. No, I can't. But I will put it up on my Two of You channel. Oh, he's done it his whole life. You're absolutely right. You're absolutely right. Yeah, he does this for every case. And that's why this judge was so amazing when he went into his order for sanctions. He went into every single line. Every single line. What does this mean in the big picture for this case? For this case that he's filed against Clinton? Well, right now it's, he's still appealing it, but this judge was so thorough about the frivolous nature and all of that. I don't see how he would win his appeal. So, I mean, that's where it's at, is he's waiting to appeal it. And he's claiming that there's this new information from the Durham report. But this judge is saying, look, I read that report. There's nothing in here. There is nothing in here that would make this case any less frivolous. And again, based off of the kinds of pleadings they did, these shotgun pleadings that they're talking about, where they're just kind of shooting everything out without any substance. How much did Trump pay after all? I don't know yet. I don't know. He was ordered almost $1 million. In just sanctions. So that's just with sanctions. The case is not done yet. That was just a sanction. So if he loses this case, which ultimately it's really looking like it, he would still have to pay, attorney's fees. So again, he was just ordered sanctions, not fees, not penalties in the case. Can he appeal it more than once? He can appeal it multiple times if he's claiming different grounds, but he's got to have fair grounds for appeal. The judge rocks. Yeah, I agree. Thank you for the live. That was so great. Oh, you're welcome. You're welcome. I'm hoping it was helpful. Is there an average cost for each appeal? I would say not in this situation. It's hard to tell because there's so many attorneys. There's so many defendants in this case. So, typically you've got filing fees, but when you consider appellate work in with attorneys, it will really vary depending on where you're at in the country. Don't news outlets just read the court papers? I know. Why don't they? I know. I mean, they go through and give kind of that brief summary, which is fine. I guess most people are interested in that, which is fine too. But isn't it possible the judge looking out could just throw it out without even, yeah, I mean, it's possible. I mean, they would need a motion. Any judge needs to have a motion in order to move on something. So the defendants would need to file a motion to dismiss or, a motion in opposition to the appeal. So, and I'm sure they are doing it. So all the judge would need to do would be to answer their motion with an order. So it's probably all set up. Would you teach us how to get access to the documents? Oh, sure. Yeah, we can go through that. If you're looking for this one, what you'll want to do is pull up this case number here, and you'll get a huge background of all different pieces of this case from the very beginning. Can all of his lawyers be open to frivolous charges? Absolutely. They absolutely can. And especially if defendants start relying on the sanctions order from this judge, which was so well put out, absolutely they could. And they can attach it each time in the future as well, much like the defamation case in New York. The really bad defamation case, she just added in the statements that he had made the day that the verdict came out. You can just kind of stockpile these things and add it on. Great many other cases. Yes, Google Scholar's really good if you know what you're looking for. A lot of times you can, if you pull up the case number itself, it'll definitely get there. But Google Scholar's amazing. That's such a great resource. Yeah, I mean, it's a lot. There's a lot. There's a lot going on here. But, again, it all kind of catches up to you. What's your schedule, or what's on my schedule to read next? So that's a great question. I do have the Menino, lost my ability to speak, the Menino indictment. I do have that indictment. That's been pretty good. And I'll probably, depending on how my voice is tomorrow, which honestly I'm not really sure, but hopefully it'll still be in good shape. I'll hope to do that tomorrow, because on Monday, there should be Trump's response to the government's motion for the DC case, right? Where Jack Smith came in and said, hey, you need to stop talking. Melendez. All right, sounds good. So his response is due on Monday. So I want to make sure that I've got time to go through that. Off to bed. Yes. Have a great night, Deborah. Always great to see you. So I'll probably do that on Monday, but I'm hoping to do the indictment tomorrow. If Trump isn't paying their legal fees, do they still need to pay the fees to the court? Yes. Yes, they do. They most certainly do. Absolutely. But so I've got that. And then I've got whatever files, whatever will be coming up at this point. We've also got pretrial coming up for the New York civil case. So I've got some of those as well. But hoping to definitely get that indictment in as soon as I can. I'm not exactly sure when, but we'll see. I'm not sure who the prosecutor is for the Menendez case. I should look into that. But it's a really interesting case, actually. I mean, interesting legally. But shame on you for bribing is not cool. Take care. Yes. Oh, yes. Oh, thank you so much. Yes, I will for sure. I probably will go ahead and sign off just so here pretty soon so I can rest my voice. I do want to get that indictment in, but what would happen if he does not pay the court fees? Contempt of court. Absolutely contempt. Oh, the Navy polish name. I don't know. I think it's called like Star Quality, I think is the name of it. I can't remember exactly. Go play some pinball. I'm going to do my pinball tomorrow. Thank you for your time and energy. You're welcome. You're welcome, everybody. Hopefully you learned something new tonight and it was interesting to you. Cece, thank you so much. I will definitely have this posted up on my Tube of You channel for sure, going through everything. Hoping to be back tomorrow at 6, depending on my voice, but definitely Monday. So either way, I will be back on Monday. Absolutely for sure. Hopefully tomorrow, but we'll see. So yes, hot tea with honey. I will have to do that. His attorneys, they'll have to pay it. Usually they pay it out of any of the, you have to put in at first, rest your voice, we need you. Yes, I will for sure. Yeah, the attorneys go have a fund that they have set up to the side that they pay all the fees out of. Yes, you're welcome. You're welcome, everybody. Thank you all. Have a fantastic night. Hopefully I'll be back tomorrow, but if not, look for me on Monday. The retainer. Thank you. I've forgotten it. I'm already tired. Yes, and as always, thanks to the moderators. You all are amazing. Have a good night, everybody. Hopefully I'll see you tomorrow. We'll see how we'll see how things go. So see you tomorrow, everybody.